Students are joining. We'll start in a minute. Hello, good morning, and welcome to Byju's Exam Prep. In the last class on Friday, we discussed previous year's question papers. We also initiated a discussion on another category of fundamental rights, right against exploitation. And there we discussed two fundamental rights, Article 23 and 24. Article 23 basically prohibits some exploitative practices. Article 23 prohibits traffic, begar, and other forms of forced labor. Article 24 basically prohibits another type of exploitation, which is child labor. And there I told you that we had a law passed in 1986, which basically prohibits child labor. What was that law? Which was amended in the year 2016. And we discussed what was the position of this law prior to 2016 and then what happened because of this law after it was amended in 2016. And there we discussed that this law, Child Labor Abolition Act, it basically prohibits the employment of children less than the age of 14 in all occupations, in all professions. But these children can work in audio-visual entertainment industry. They can help their family business as well. And for the first time, this law is also talking about adolescents, those in the age group of 14 to 18. And these adolescents are prohibited from being employed in hazardous industries. But these adolescents can still work in non-hazardous industries. But in non-hazardous industries, their conditions of work can be regulated. Regulated in the sense that minimum number of hours, minimum wages should be paid. Then I told you in the last class that on Monday we will conduct an analysis of this law. What are the arguments in favor of this law? What are the arguments against this law? Let's discuss. What are the arguments in favor of this law? Let's discuss them one by one. First argument is that this law is compatible with Article 21, capital A of the Constitution. So now children in the age group of 6 to 14, they have a fundamental right to primary education. This fundamental right was getting compromised because these children would still be allowed to work in non-hazardous industries. But now there is no such limitation. On one hand, the children in the age group of 6 to 14, they can enjoy their fundamental right to primary education, and at the same time, they cannot be employed in any industry, whether hazardous or non-hazardous. So this law is in agreement, is compatible with the fundamental right under Article 21, capital A. Similarly, this is an agreement with United Nations Convention on the Rights of the Child. And India is a signatory and has ratified this United Nations Convention, which says all forms of exploitation against children should be abolished, should be prohibited. That's argument number 2. Argument number 3, all the children in the age group of less than 14, they cannot be made to work in any industry. Whether this industry is hazardous detrimental to the life and the security of a child, or this industry is non-hazardous. Doesn't matter, these children cannot be employed under any circumstances. So we are prohibiting the exploitation of children as well. We are abolishing child labor. Fourth, but these children, they are of impressionable age. Whatever they learn, they are going to carry forward that learning for their entire life. So tomorrow's superstars, tomorrow's musicians, tomorrow's artists, they have to come from this group. So one opportunity is provided to these children that you can work in audio visual entertainment industry. But the condition is you can work in audio visual entertainment industry either after school hours or during vacation. Which means even if a child in the age group of less than 14 is allowed to participate in audio visual entertainment industry as child artists, as musicians, as artists, to explore their creative potential, but even it does not compromise with the fundamental right to primary education, because they can work in audio visual entertainment industry only after school hours or during vacation. And at the same time, circus, which is one exploitation practice, they cannot be made to perform in a circus because that is exploitation. So circus is excluded. That's another best point about this law. And the beautiful part about this law is, for the first time, our policy makers under child labor, they are talking about adolescents in the age group of 14 to 18. And these adolescents can work in non-hazardous industries, but these adolescents are prohibited from being employed in hazardous industries. So we have taken a step further to protect the interests of the adolescents as well. All these points put together, they clarify and substantiate that this law is a beautiful law. In fact, Kailash Satyarthi, who works for the betterment of the children throughout the world, is also a Nobel Peace Laureate, has won the Nobel Peace Prize. He has basically supported this law, saying that this law is an agreement. This law is the best of both worlds. This law, on one hand, allows children to explore their creative potential so that tomorrow they can become our superstars, they can become our musicians, they can become our talented individuals. And on the other hand, it does not compromise with their fundamental right to primary education. And he was particularly appreciative of the fact that this law is dealing with adolescents in the age group of 14 to 18. But then there are some concerns. What are concerns about this Child Labor Abolition Act or Child Labor Amendment Act, which was passed in 2016? Concern number one is, imagine a situation where we have a children less than the age of 14. They have the fundamental right to primary education. 8 years of continuous schooling is their right. But at the same time, we are allowing them to work in family business. But when are they allowed to work in family business? After school hours and during vacation. The point is that this law does not talk about number of hours that these children can work in family business. So after school hours, during vacation, this is the time when a child has to perform other activities, for example, sports, for example, getting to know other kids as well. And this law is saying that this child in the age group of less than 14, he can help the family in their business after school hours during vacation. But the law does not define the minimum number or the maximum number of hours that this child has to work. And after school hours, they have to also do their homework. After school hours, they also have to participate in the sports activities. after school hours, something beautiful starts in the life of these children, which is their childhood. So this law is basically snatching the most important part and parcel of a child's life, which is their childhood. That's problem number one. Problem number two is that this is specifically against the interests of the girl child. How? In India, unfortunately, as soon as a family gets to know that the child in the womb of the mother is a girl, she's killed. Even if by hook or crook she survives, but then we discriminate against her. How? Best food, nutritious food, best education, best set of clothes are reserved for a male child. And for the girl child, she is discriminated against. Now imagine this girl child who gets up early in the morning, attends the school, and once she comes back from the school, she assists the family in the family business. Let's say the family business is fixing the collars. For example, her mother, her father, they have a business. The business is they help a particular factory in manufacturing the shirts. And they specifically have a job of fixing the collars on the shirt. Now, this girl child, after school hours, she is not given nutritious food, but she has to help and assist the family in the family business, which means we are snatching her childhood, which means we are snatching her access to sports facilities as well. And then this child works for a long number of hours fixing these collars. Then, without any nutritious food, she goes to sleep. And then, early morning, she has to wake up and go to the school again. Where is the energy in her that she will help the family business without completing the homework? She will get down and then start practicing in the school as well. So, that is another flaw with this law. And at the same time, we can have something known as surrogate child labor. What is surrogacy, for example? In simple terms, there is a family, there is a couple, husband and the wife. They are both working. One argument is they're working, so they don't have time to bear the child. So, what they will do, they will ask another lady, a surrogate lady, and then the egg and the sperm of the couple embryo will be fertilized, and then this embryo will be injected into the womb of this surrogate lady. She will bear the child. Clear? Or the wife or the husband, they are unable to procreate, they are unable to have a child, which basically means they will call someone else to bear the child for them. Surrogate. That means she is not the real mother of the child. Similarly, what will happen, there will be a lot of surrogate labor. I am a very, very shrewd industrialist or factory owner. For example, I'm rolling BDs. Now, what do? I am looking out for a family which has a large number of children as well. So, mother, father, they have 10 kids, or they have 6 kids, or they have 5 kids. What I will do, I will set up a BD factory in their name. And then I will employ their children to roll the BDs. Which means when these children can be made to work in family business after their school hours during vacation, what is happening, what can also happen is that there will be one selfish individual who will set up a BD rolling factory in the name of a family and then employ their kids. And then these kids will not even go to the school. These kids will not go to the school, but they will help this so-called family business. So it's basically a surrogate child labor, surrogate business. That's another problem with this law. Third, and the fourth one is important. We have said that this law is beautiful because for the first time, this law is taking into account the interests of adolescents in the age group of 14 to 18. That means these adolescents cannot work in hazardous industries, but they can work in non-hazardous industries. Previously, there used to be hundreds of industries which were considered hazardous, where children cannot be employed. What this law has done, it has slashed the number of hazardous industries to only 3. So previously, there used to be about 83 industries or occupations which were considered to be hazardous, where you cannot employ the children. Now we are saying adolescents also cannot be made to work in hazardous industries. But what we have done, we have technically allowed them to work in hazardous industries. But the only thing is, we are calling them non-hazardous, which means previously there were 83 hazardous industries. Now these 83 hazardous industries had been slashed to 3. That means although the 80 others, they're also hazardous, but we call them non-hazardous. And adolescents can work in these non-hazardous industries, which technically previously were hazardous. And the bigger problem is this number 3 can be reduced from 3 to 2, from 2 to 1, from 1 to 0, not by the parliament, but by the bureaucrats, by the government. So the government bureaucrats will have the power to reduce the number of hazardous industries under this law. It has reduced it from 83 to 3. Now they have the power to reduce it from 3 to 2, then 2 to 1, then 1 to 0, which means although there are no industries which are hazardous technically, but in reality, these are hazardous industries, but we are allowing these adolescents to work in hazardous industries. That's another problem with this law. And that is why there are experts who say these 2016 amendments, they do not prohibit child labor. In fact, these 2016 amendments, they allow child labor. How? By allowing the kids to work in the family business after school hours and during vacation. By allowing the kids to work in audiovisual entertainment industry. By not fixing the number of hours that they will have to work on a particular day. By allowing adolescents to work in hazardous industries. But the only thing is, we don't call them hazardous now because we have removed them from the list of hazardous industries. And this number 3 can be reduced to 2, reduced to 0, not by the parliament. That means there will be no parliamentary oversight, but can be removed by the executive, by the government. That's another bigger flaw with this law. Similarly, Section 3 of Clause 5, it allows child labor in family or family enterprises, allows the child to be an artist in audio-visual entertainment industry. But look at the point. In India, most of our work is caste-based. So you go to a cobbler. It can be a family business. It's basically caste-based. A particular community, a particular caste group, primarily members of the Dalit community, they are the cobblers. Now here what we are saying that this is a family, they have a child. This child can help the family business, but after school hours and during vacation. Which family business? Which is caste-based. That means you will help the family in fixing the shoes. That means we are perpetuating caste system through this law. And at the same time, this clause is dangerous because it does not define the number of hours of work. It simply states that children may work after school hours and during vacation. That's another problem with this law. Similarly, what we have said is that what was the intention of the government, intention of the parliament in passing this law? The intention was that we will allow these children to assist the family in the family business. Why? Because this family may be involved in some art form, some craft, and we have to preserve that art craft. For example, there is a family which works in paper mache industry. That means using the papers, they make flower vases, they make beautiful devices. Clear. Paper mache or wood carving or some other art form, for example, carpet making. So these children can assist the family business after school hours during vacation so that we preserve these crafts as well, so that the craft and art of paper mache is not extinct, so that the art and craft of wood carving does not become extinct, so that the art and craft of carpet weaving does not become extinct. Now, why don't we do one thing? Why don't we ask these experts to go to every school and in fact communicate this art craft, train students, all the students in these art forms. So what we can do, we can create our curriculum in such a manner that we are inviting experts. We are inviting these fathers and their mothers to go to a school and teach all the kids, not only their kids, teach all the kids the art of paper mache, wood carving, carpet weaving, other skills, other arts, other crafts, so that these crafts do not die. Why are we allowing only their kids to be given this art and craft training? Why not others? That's another key issue that this question has raised. And at the same time, when we look at this child labor law, this child labor law allows a child to work in audio visual entertainment industry, which can also be, for example, the reality TV shows. But the only thing which is real about these reality TV shows is that these are unreal. There is no reality in the reality TV shows. Instead, what there is negative competition. There is horrible competition. So at a very impressionable age, at a very young age, we are injecting into these kids and their minds some of the negative competition that you have to come first, otherwise your life is gone. That's how these kids, they weep, they cry during the reality TV shows, and then because of the TRP, higher the television rating points, higher ad revenue that a news channel will get. How do these news channels get the revenue? How do these entertainment TV channels get the revenue? If you and me watch, that means television rating point for every watch time, they get the points. And then these points they share with the advertisers. Higher the TRP of a show, higher the TRP of a channel, more advertisers would want to advertise their content on these news channels or these entertainment channels, which means in the name of TRP, for the sake of TRP, they zoom these cameras into the eyes of the crying kids and then injects negative mindset in their thought process. You have to come first, otherwise your life is gone. Instead, if you really are concerned about building the art in a child, why don't we do something else? Allow these kids to participate without winners, without losers. Allow these kids to explore their creative potential without declaring somebody a winner and the other a loser. That's how we can inject some kind of positive commitment and competition amongst these children. Now, you may not even agree with me, but these are the disagreements with this law. We have already praised this law. Now we are criticizing this law. Why? Because the question can be write an argument in favor of child labor amendments or write an argument against them. And we have discussed both of them. And Article 24 is over. Any question as of now? Okay. Now let's look at another category of fundamental rights, right to freedom of religion, where we will have to discuss Articles 25 to 28. But before we start, there is a disclaimer. What is the disclaimer? You go to a multiplex, you watch a movie, you want to watch a movie, and when the movie starts, the first thing is disclaimer. All the characters in this movie are purely fictional. There is no resemblance to any person living or dead. We are not trying to polarize people in the name of religion, caste, so on and so forth. That's the same disclaimer that I will make before I start this topic. Whatever I'm going to say, whatever arguments I'm going to put forward, these are not my arguments. I have read few books, few articles. Based on that, I have come up with this lecture. So don't hold me accountable for whatever I'm going to say, because religion is a very emotional issue. Don't lynch me if I criticize one religion more, the other religion less. But this lecture is going to be purely driven from the examination point of view. You will not come to know what is my personal thought process, what is my personal ideology. Clear? So all that I'm going to speak in this lecture now, these are not my words. So hold them accountable who have written these books, who have written these articles, not me. Don't lynch me. Okay? Perfect. Article 25 gives us two-fold fundamental right, two sets of fundamental rights: freedom of conscience, and then freedom to profess, practice, and propagate your religion. Now, what is Article 25 telling us? The text of article is slightly different. When we look at other fundamental rights, we looked at that first Constitution gives us fundamental rights and then imposes restrictions. For example, you have freedom of speech and expression, but reasonable restrictions can be imposed on 8 grounds. You have right to life and personal liberty, but it can be snatched based on the procedure established by law. The state cannot discriminate only on the grounds of religion, race, caste, sex, place of birth, but then there can be some exceptions. But 25 article is slightly different. That Constitution first imposes restrictions and then gives you a fundamental right, because they know Indians are too attached and emotional about their religion. Article 25 says, subject to public order, subject to morality, subject to health, and subject to other provisions of this part. And which is this part? Part 3 of the Constitution. That means, first, on the grounds of public order, on the grounds of morality, on the grounds of health, subject to other provisions of this part 3 of the Constitution. That means subject to right to equality under Article 14, subject to non-discrimination under Article 15, subject to freedom of speech and expression under Article 19, subject to right to life and personal liberty under Article 21, subject to other provisions of this Constitution. All the persons residing within the territory of India, they have a fundamental right. And what is that fundamental right? They are entitled to freedom of conscience and freely profess, practice, and propagate their religion. What is Article 25 to 28? Comes under the category right to religious freedom. First, we will discuss Article 25, the most important fundamental right, and we will have an elaborate discussion on Article 25. Then we will look at Article 26, 27, and 28. Clear? But what is Article 25? The difference here is that Constitution first imposes restrictions. First talks about exceptions. That subject to public order, subject to health, subject to morality, subject to other provisions of this part 3 of the Constitution, all persons, which means not just citizens, but also aliens. What will they have? They are entitled to something. And what are they entitled to? Two sets of fundamental rights: freedom of conscience and freedom to profess, practice, and propagate your religion. What is freedom of conscience? Innermost freedom. I have the freedom to choose a religion. I have the freedom to choose a different religion. I have the freedom from religion as well, because conscience can keep on changing. I may love the philosophical, moral, or supernatural stories of Christianity, and I want to embrace Christianity. That's my fundamental right. I want to come out of Christianity and enter the fold of Hinduism. That's my fundamental right. So freedom of conscience is basically absolute. No restrictions whatsoever. Because how can you control my conscience? Conscience is my innermost freedom. I have the freedom of conscience to choose a religion. I have the freedom of conscience to change my religion. I have the freedom of conscience to come out of all these religions. That means freedom to choose a religion, freedom from religion is my fundamental right. I can stay atheist. I can reject all religions. I can stay agnostic. Agnostic in the sense, I don't really care whether God exists or not, whether God is a reality or not. I don't care at all. I'm an agnostic. Doesn't matter whether there is God or not. But atheists are those who reject the existence of God. They say there can't be anything as God. That's freedom of conscience. But once your conscience is clear, it takes an outward form. And once you've made your conscience clear that I am a Hindu, for example, then you have another fundamental right. And what is that fundamental right? You can freely profess, I am a Hindu. This open profession that yes, I am a Hindu, is your fundamental right. You can practice the rituals of Hinduism. That's your fundamental right. You can propagate your religion as well. That's also your fundamental right. So Article 25 says you have the fundamental right to freedom of conscience. And once this conscience takes an outward form, once your conscience tells you that I believe in Hinduism, then you can profess, practice, and propagate your religion. But this professing, practicing, and propagating your religion is not an absolute fundamental right because it comes under restrictions. Which are these restrictions? For example, public order. What is public order? Basically, peace in the society. Same day, there is Durga Pujo festival, there is Muharram as well, of two religious communities, Hindus and Muslims. For example, we are in West Bengal, we are in Kolkata. Now, Muharram as well as Durga Puja festival falls on the same day. If we allow both these sets of communities to organize rallies, to organize programs, maybe passing through the same lanes and by lanes and streets of Kolkata, there will be elements who will try to vitiate the atmosphere. There will be elements who will try and initiate and ignite a spark, and ultimately there will be riots. So, what the government can do, impose restriction. That Durga Puja festival will be restricted to these parts of Kolkata. Muharram procession will be restricted to these parts of Kolkata. Can you approach the court and say, my lord, my fundamental right has been violated? What fundamental right? Article 25. It says I have the fundamental right to freedom of conscience. I said, okay, sir, I made my conscience clear that I'm a Hindu. Another person says, sir, I have made my conscience that I'm a Muslim. Okay, so what's the problem? Sir, now I want to profess my religion. I said, profess it. Sir, I want to practice my religion. So practice it. But the government is not allowing. Why? Because the government is saying you cannot pass through these streets. Government, what are you saying? Sir, we are saying don't pass through these streets because for these streets, we have allowed access only to the Hindus. On these streets, we have allowed access to Muslims. Can you discriminate on the grounds of religion? Yes, sir, we can. How? Because this professing, practicing, propagating your religion is not an absolute fundamental right. In the interest of public order, we can impose restrictions on your freedom of religion as well. Another interesting case. Reverend Father Stanislaus versus State of Madhya Pradesh, 1977. The father, the head of a church, was accused of converting people from other religions to Christianity. That was the allegation. And then the state of Madhya Pradesh passed a law, the legislature of Madhya Pradesh passed a law against these forcible conversions. That means forcefully you cannot convert people into your religion. Father Stanislaus approached the court and said, my lord, I have a fundamental right. Said, what is your fundamental right? I have the fundamental right to convert others into my religion. The court said, where is it mentioned? Father said, look at Article 25 of the Constitution. I have the fundamental right to freedom of conscience. I have made my conscience clear that I belong to Christianity, that I'm a Christian. Now I can openly profess that I'm a Christian. Now I can openly practice the rituals of Christianity, and I can also propagate Christianity. What is this propagation? That means I will tell others the beautiful stories about Christianity, and I can convince them that you should ditch your religion and you should embrace Christianity. So right to propagate my religion gives me the fundamental right to convert others into my religion. The Supreme Court said you do not have the fundamental right to convert others into your religion. The father asked, then what is the purpose of Article 25? Supreme Court elaborated. Supreme Court said, first is freedom of conscience, your innermost freedom. If your innermost freedom wants to tell you that you want to change your religion and embrace Christianity, we will have no problem whatsoever. But if you are propagating your religion, and through this propagation, you are giving bribe, you are giving threats, you are giving inducements. If through bribe, through inducements, through threats, you are basically forcing people to convert from their religion to Christianity, it is not your fundamental right. The father asked, then what is the purpose of propagation? The Supreme Court said, tell them the stories about Christianity. Tell them the brilliant stories about Christianity. Maybe the supernatural stories about Christianity as well. And through these stories, through this propagation, because that is your fundamental right, if you touch their conscience and they voluntarily change their religion and convert from their existing religion to Christianity, we will have no problem whatsoever. Because freedom of conscience is absolute. Once an individual has made his conscience clear, we cannot restrict that conscience, because how can we restrict the mindset of an individual? Conscience is mindset. But if through these supernatural stories, through your philosophy, through your practice of equality, if you're changing, touching the conscience of an individual, and once their conscience changes, if they want to embrace Christianity, we will have no problem whatsoever. But it should be voluntary. If you bribe people, it's not voluntary. If you threaten people, it's not voluntary. If you induce people, it is not voluntary. For conversion, in order to be valid, it must be voluntary. It must be touching the conscience of an individual. That form of fundamental right you have, but you don't have fundamental right to convert others into your religion. But something else has also happened. We say the state can regulate or restrict any economic, financial, political, and other secular activity which may be associated with the religious practice. For example, there are temples in India, Hindu temples in India, which are under the control of the state. The state is controlling these temples. That means financial activity of a religion, political activity of a religion, economic activity of a religion, or any secular activity of a religion can be restricted. Restricted in the sense, if there is a religious institution which is taking a lot of donations from the public, which is taking a lot of charity from the public, but then this money is siphoned off, this money is abused, there is corruption involved in the spending of this money, the state cannot act as a mute spectator. The state will have to come, interfere, and restrict these activities of a particular religion. That is the exception under Article 25. Exception also is the state is provided the power. Fundamental thing about Article 25 is reform. Reform in the sense, all Hindu temples, specifically Hindu temples, not of any other religion. Why? Because it was argued that it is these Hindu religious institutions which are basically discriminating people on the grounds of caste. For example, Dalits are not allowed entry inside the religious temple. They can contribute for the construction of a temple. They can sweep the stairs of the temple, but they cannot enter the temple. So that form of discrimination is also to be arrested. That form of discrimination is also to be discarded. And that is why Constitution, specifically under Article 25, talked about social reform, social welfare, where all these Hindu religious institutions are open to all classes and sections of Hindus. That's another exception. But then something else. When we look at a religion, now listen to me carefully. You have the fundamental right to freedom of conscience, and then you have the fundamental right to profess, practice, and propagate your religion. What if through this propagation you are violating other fundamental rights? Fundamental rights of other members of the society. What if there are some features of a religion which are anti-women? What if there are features of this religion which are basically discriminatory? How? Shurur Mat 1954 case. The Supreme Court invented a doctrine, an important doctrine known as doctrine of essentiality, which is also known as essential religious practices test, ERP. What is that essential religious practices test? If there is a religion and then this religion has some features, if these features are essential, some of these features are essential, some of these features are non-essential. If these essential features violate fundamental rights, we can do nothing. State cannot interfere. The judiciary cannot interfere. But if there are some non-essential features of a religion, they can be restricted by the state. How restricted by the state? I will give you two examples. For the sake of equality, we will discuss a Hindu example, we'll discuss a Muslim example, so that there can be no accusation on me. Sabrimala, a temple in Kerala where the deity is Lord Ayappa. Lord Ayappa is a celibate brahmachari, or some say Neshtika brahmachari, eternal celibate. Now in Sabrimala, there were rules. What were these rules? That women in the age group of 10 to 50, they are not allowed entry inside the Sabrimala temple. Sabrimala is a temple, a hilly temple in Kerala, where the deity, the presiding deity, the god is Lord Ayappa. Lord Ayappa is a celibate, brahmachari or Neshtika brahmachari, eternal celibate. Now the temple authorities have made rules, and the rules are that women in the age group of 10 to 50, women of menstruating age, in the age group of 10 to 50, they are not allowed entry inside the sacred sanctum sanctorum, inside the part of the Sabrimala temple. Why? Because these are the rules. Now, these rules were challenged before the Supreme Court. 5 judges of the Supreme Court had to decide whether these rules are constitutional or unconstitutional. Whether these rules are constitutional or unconstitutional. And for that, they specifically had to decide whether this ban on not allowing the women of a particular age inside the sacred sanctum sanctorum of the Sabrimala temple, whether this is essential religious practice or not. If it is essential religious practice, we will not interfere. If it is not essential religious practice, we will discard. Why? Because in Shurur Mat case 1954, The Supreme Court said that now we have the power. What judiciary has the power? It will look at a particular religion and will identify essential features of a religion, non-essential features of a religion. Essential features in the sense, if there are some features in a religion which are so important that if we remove them, if we discard them, religion will collapse. But then there are non-essential features of a religion. If we discard, if we remove them, nothing will happen to the religion will survive. For example, Islam. There are 5 important tenets of Islam. 1, you will have to have a belief in God and the Prophet. Second, you will have to pray 5 times in a day. Third, you will have to fast for 1 month. Fourth, you will have to pay 2.5% of your income every year for charity. 5, if it is possible, if you have the means, if you have the money, you can go on a pilgrimage to the holy cities of Makkah and Medina. These are the 5 basic principal tenets of Islam. Praying 5 times a day. Can you go to the court and say, my lord, this is discriminatory? I said, why? I cannot pray 5 times a day. Please issue an order that all the Muslims should be allowed to pray or should be required to pray only once in a particular year, or at least once a month, or at least once a day. Allowing and forcing or prescribing Muslims to pray 5 times in a single day, this is exploitation. This should not be allowed. What the court will do, court will look at these features of Islam and will then decide, is praying 5 times a day an essential practice of Islam? If it is, then we will not restrict it. We will not interfere. Why? Because this is an essential feature of Islam. If we remove it, Islam will collapse. That's something that we will not allow. And now court, what it will do, it will look at the religious texts of Islam. It will look at some commentary on Islam. Maybe it will ask the religious scholars, you tell us, you assist us, whether in Islam praying 5 times a day is essential or non-essential. If it is essential, the court will not restrict. The court will not interfere. But then if praying 5 times a day is an important part of Islam, but where can you pray? Can you pray inside your home? Or are you necessarily required to pray in a mosque? That's the question that Supreme Court had to answer in 1994 in Ismail Faruqi case. What happened in this case? There was a dispute on 2.77 acres of land in Ayodhya. It was argued that once on this piece of land, there was Lord Ram's temple, which was demolished by Babur, and ultimately a Babri Masjid was constructed on this site. And then Babri Masjid was demolished. Why? Because people wanted a mega Ram temple should be constructed on this disputed site. When this Babri Masjid was demolished in 1992, what the central government did? Central government issued a law, passed a law. And through this law, what it did, all the land surrounding this 2.77 acres of disputed land was taken away by the state. What happened because of this law? There was a dispute on 2.77 acres of disputed land. The surrounding land consisted of some temples, consisted of some mosques as well, consisted of some graveyards as well. And by passing a law in 1992, what the parliament did, parliament gave all these lands to the central government. Now, central government is the owner of this land surrounding this 2.77 acres. Matter went to the court. My lord, I have a fundamental right to religion. Said, okay, which religion? Islam. Then what is your problem? Sir, the issue is that parliament has passed a law and has given this land, which includes mosques, which includes graveyards, to the central government. This violates my fundamental right because I have to pray at a mosque. Now, court had to decide whether praying at a mosque is essential feature of Islam or non-essential feature of Islam. If it is essential, then we will not interfere. That means we'll have to give these mosques back to the Muslim community. If it is not an essential feature, then mosque can be acquired by the state. And the Supreme Court in Ismail Faruqi case 1994 said, Praying 5 times, yes, can be an essential feature of Islam. But where can you pray? You can pray at a mosque. You can pray at your home. You can pray in the open field. That cannot be your fundamental right. Which means mosque is not an essential feature of Islam. When it is not an essential feature of Islam, that means it can be acquired by the state. So now, because of this Shurur Mutt case, 1954, the judiciary has the power. The judiciary has the power to look at a religion and then look at some essential features of a religion, some non-essential features of a religion. If there are essential features of a religion, even if they are exploitative, the court cannot come to your rescue. But if there are some non-essential features, the state can restrict it. That's what happened in 1994. And now in Sabarimala, in 2018, 5-judge bench of the Supreme Court had to decide whether this rule prohibiting the women of menstruating age in the age group of 10 to 50, whether banning them entry inside the sacred sanctorum of the Sabarimala temple, whether it is essential feature of Hinduism or non-essential. 5 judges of the Supreme Court gave a verdict by the majority of 4:1. 4 judges, Justice Deepak Misra, Justice Khanwilkar, Justice Chandrachud, Justice Rohinton Fali, they said that this ban on the women of menstruating age inside the sacred sanctorum of the Sabarimala temple, this ban is unconstitutional. This is not an essential feature of Hinduism. Only one judge dissented. Her name is Justice Indu Malhotra. The only woman member on this bench. She dissented, she disagreed, said, no, this is an essential feature. And court should not get to decide what is essential to a religion and what is not essential to a religion. Why? Because you may be an expert on constitution. You may be an expert on criminal laws, civil laws, property laws. You may be an expert on the constitutions of other countries as well. But you don't have religious experience. You don't have religious expertise. You cannot sit on the judgment and decide what is essential to a religion, what is not essential to a religion. What is essential to a religion, what is not essential to a religion, we should give it to the members of that community. Let them decide what they consider is essential to them, non-essential to them. The court should not sit on this judgment. That was Justice Indu Malhotra. But other judges said, no, this ban is unconstitutional. In fact, Justice Chandrachud looked at this ban from the prism of Article 17 as well. What is Article 17 saying? Untouchability is abolished and its practice in any form is forbidden. In any form is forbidden. Till this judgment, we realized that this untouchability can be on the grounds of caste. That means caste-based untouchability is abolished and prohibited by the Constitution. Justice Chandrachud, who is now the Chief Justice of India, linked this issue with Article 17 and said this is untouchability. You are calling women of menstruating age as some sort of untouchables because of their impurity. They are not allowed entry inside the sacred sanctorum of the Sabarimala temple. This is untouchability. And untouchability practiced in any form is forbidden in the Constitution. And that is why, in the name of Article 17, these rules are unconstitutional. Women of all age groups may pray at Sabarimala. The Supreme Court went a step further. Supreme Court said, what is the implication of these rules? Implication is that if there are men who have to go on a pilgrimage to the Sabarimala temple, first what they have to do, they have to take a vow. Vow of abstinence. That means before they embark on this journey to go to the Sabarimala temple, they have to take a vow, a promise that for 42 days we will abstain from sex. We will abstain from sexual intercourse. And the argument given by the temple authorities was that women cannot take this vow. They cannot abstain from sex for 42 days. The Supreme Court said you are imposing unnecessary condition on a woman. Do you consider them as weak individuals who cannot abstain from sex for 42 days? That means you're saying that they cannot take this vow of abstinence just because they menstruate after 28 days or a month. These are unconstitutional rules. We will not allow. Women of all age groups may pray at the Shabrimala. But it raises a larger, bigger question. Should the judiciary be the deciding authority to decide what is essential to a religion and what is not essential to a religion? Something happened in Australia. The Australian Supreme Court said, what is religion to you may be superstition to somebody. What is religion to you may be magic to somebody. And in religious matters, we will not interfere. Who says this? The High Court of Australia in Jehovah's Witness versus Commonwealth. In that, the Australian court said, what is religion to one may be superstition to another. So in religious matters, we will not interfere. And in India, what Supreme Court says, Indian Supreme Court says, we will decide what is essential to your religion, what is not essential to your religion. So in other courts, in Australia, for example, the courts do not interfere in religious matters. But Indian Supreme Court has become so powerful that now it decides what is essential to a religion, what is not essential to a religion. And the classic example of that is this Shabrimala case, where Supreme Court, by the majority of 4:1, said women of all age groups may pray at this Shabrimala. Because these rules which prohibit the entry of the menstruating age women in the age group of 10 to 15, these are not essential features of Hinduism. This is not an essential religious practice. Once it is not an essential religious practice, if it violates fundamental rights, we will strike it down. Why? Because the petitioners in this case said Article 14 is violated, right to equality. So why should men be allowed to pray and not women? Article 14 is violated. Article 15 is violated. You cannot discriminate on the grounds of sex. Article 21 is violated, which means right to life and personal liberty. Article 25 is violated, which means the fundamental right to practice your religion. So women said, why can't we practice our religion? We also want to go to the Shabrimala. We also want to pay obeisance at the deity. Why should men have all the fun? Why should only they be allowed and not women? This is unconstitutional on these grounds. But on religious matters, what has the Constitution said? Subject to public order, subject to morality, subject to health, and subject to other provisions of this part, other provisions of Part 3 of the Constitution. You have the fundamental right to freedom of conscience and freedom to profess, practice, and propagate your religion. You can propagate your religion, practice your religion, but then court will decide what is essential to your religion, what is not essential to your religion. If something is essential, we will not touch it. If something is non-essential and it violates other fundamental rights, we will strike it down. And that is what the court also did in the triple talaq case. In triple talaq case, although we don't have to go too deep into this, but just for the sake of clarity, husband and wife. In Islam, husband has the right to grant the divorce to his wife. Wife cannot grant the divorce. Wife can only request for a divorce, seek divorce. But granting divorce is the right given only to a husband in Islam. Tomorrow there can be a decision in the court whether this right should be given to a woman as well. And now the court may have to decide whether this granting of right to divorce only to a man, is it an essential practice of Islam or not? If it is essential to Islam, only husbands will have the right to divorce. If it is not essential to Islam, then women may also be given the right, you can also divorce your husband. But this husband was granting divorce to his wife by uttering talaq, talaq, talaq 3 times in a single utterance. 3 times continuously together, if the husband would have said talaq, 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 the divorce was granted. Matter went to the court. 5 judges of the Supreme Court had to decide whether this instant triple talaq, whether it is essential part of Islam or not, whether it is essential to Islam or not. And ultimately, the court decided that instant triple talaq is invalid. But the court did not say it is unconstitutional. Why? Listen to me carefully. There were 5 judges on this bench. Justice Kehar, who was then the Chief Justice of India, Justice Nazir, who is now appointed as the Governor of Andhra Pradesh. 2 judges, Justice U.U. Lalit and Justice Rohinton Fali Nariman. And the 5th judge was Justice K.M. Joseph, Justice Kurian Joseph. Instant triple talaq, where the husband says talaq, talaq, talaq 3 times in a single utterance to his wife and the divorce is granted. Is this exploitation? Because the women alleged that we are given talaq on WhatsApp, on Skype, by sending a postcard. This is exploitation. This is against the dignity of a woman and as such should be declared unconstitutional. Petitioners claimed violation of fundamental rights. Respondents, they claimed that this is freedom of religion. Freedom of religion is also our fundamental right. And now the court had to decide whether this is essential to Islam or non-essential. If it is essential, we will not interfere. If it is non-essential, we will interfere. 2 judges said, Chief Justice of India, Justice Kehar and Justice Nazir, that instant triple talaq is not unconstitutional. Why? Because instant triple talaq is part of Islam. Islam is a religion. Right to religion is a fundamental right. So instant triple talaq can be deemed as fundamental right. Why? Because every religious community has its own features, has its own practices. And since right to practice your religion is a fundamental right, even these practices are fundamental right. We will not interfere. Yes, if Parliament wants, they may pass a law, and through that law, they may declare instant triple talaq as unconstitutional, or they may impose restrictions on it. But we will not interfere because instant triple talaq is not unconstitutional. These 2 judges, Justice U.U. Lalit and Justice Rohinton Fali Nariman, they said instant triple talaq is unconstitutional. Why? Because it violates fundamental rights. And in any case, instant triple talaq is not an essential feature of Islam. When it is not essential feature of Islam, then it means it can be set aside. Now the ball is in the court of Justice Joseph, Kurian Joseph, because there are 5 judges. 2 judges are in favor that instant triple talaq should continue. 2 judges are against instant triple talaq cannot continue. Now this judge has to decide whether he is in favor or he is against. But Justice Kurian Joseph implemented something else. Looked at this question from something else. Without getting into essentiality or non-essentiality, he looked at it from a different prism. He said in Islam, there are some conditions for divorce. One condition is there should be some scope for reconciliation, and there should be some form of arbitration as well. Arbitration as well, in the sense, husband and the wife, they have a conflict. They want to divorce each other, or husband wants to give divorce. For divorce to be legalized, for divorce to be formalized, according to Kurian Joseph, there are 2 requirements in Islam. First, there should be arbitration. That means maybe their family members will come and talk to them, said, what are you doing? You look beautiful together. These things happen in every marriage, every relationship. What is your point of concern? What is your objection? What is your objection? Maybe there is a meeting point. So there will be family members or village community or some elders, they will try and solve the dispute between the couple. If arbitration fails, then divorce will be taken. Or there can be reconciliation. That means without involving the third party, husband and the wife, they can still come together. Sorry, I was under the influence of drugs, liquor. Sorry, I was under the stress. You know what's happening in the office, blah, blah, blah. And ultimately, they'll say, okay, I forgive you. I forgive you. Now they have reconciled. There should be a period of reconciliation. There should be a period of arbitration. And Justice Joseph said, since instant triple talaq, when you instantly say talaq, talaq, talaq 3 times in a single utterance, there is no scope of arbitration. There is no scope of reconciliation because it is given divorce right then and there. So Supreme Court's Judge Justice Joseph said, instant triple talaq is un-Islamic. When it is un-Islamic, that means it cannot be allowed to continue. But now if 2 judges said unconstitutional, 2 judges said constitutional, and Justice Joseph did not look at it from constitutional and unconstitutional prism, it only looked at it from Islamic and un-Islamic practice. That means instant triple talaq will still not continue because 3 judges are in favor of it not continuing. 2 judges on the grounds of constitutionality, 1 judge on the grounds of Islamic or un-Islamic thing. And ultimately, that is why we say instant triple talaq was declared invalid, was not declared unconstitutional. But be that as it may, it is that the courts will have now the power to decide what is essential to a religion, what is not essential to a religion. In Shabarimala case, reiterating what was said in Shurur Mutt case, if this is the question asked in your exam, this is what you can write. The court held that the term religion will cover all rituals and practices which are integral to a religion and took upon itself the responsibility of determining what is essential and non-essential practices of a religion. And there are critics who say this essentiality doctrine, this doctrine of essentiality has tended the court into an area which is beyond its competence. A judge may be competent on civil law, criminal law, constitutional laws, comparison of the world constitutions, but the judge is not competent to decide the matters related to religion. So this doctrine has tended the court and led the court into an area which is beyond its competence. And that is why there are critics who criticize this doctrine, saying judiciary should not have this power. And in the Shabarimala case, five judges of the Supreme Court said patriarchy cannot trump religion. So these rules which prohibit the entry of women of 10 to 50, the smacks of patriarchy as such should not be allowed. On one side, that's what the court said. Justice Deepak Misra, Justice Khanwilkar, they said on one side we pray to goddesses. On the other hand, women of a certain age are considered impure. This dualistic approach is nothing but patriarchy, where we want to exact more purity from women than men. Men can be allowed to visit the temple, but women cannot because she is menstruating. This is patriarchy. That is why these rules are unconstitutional. Justice Khanwilkar and Justice Deepak Misra went a step further. They said there can be distinction between man and a woman. Psychologically, they may be different. Physiologically, they may be different. Physical appearance may be different. But they still have the same rights guaranteed by the Constitution. And if these rules are against women, they are zealously propagated. They are not essential part of religion. Everybody should have the equal right to practice his religion, her religion, and to practice the religion which is created by the God. Justice Khanwilkar went a step further. They said that there are these rules, Kerala Hindu places of public worship rules, under which there was a ban on the entry of menstruating women inside the sacred sanctum sanctorum of the Shabarimala temple. Supreme Court said these are ultra vires of the Constitution. unconstitutional. This right to worship is equally available to men as well as women. Justice Chandrachud, he said, you are treating women as the children of a lesser god. And if you think like that, you are blinking at the Constitution. You are violating the Constitution. You are disregarding the Constitution. You are basically practicing untouchability. And this untouchability is abolished under Article 17 of the Constitution. But Justice Indu Malhotra, as I said, she disagreed with the other members of the bench. She said court should not have the power to decide what is essential to a religion, what is not essential to a religion. What is and what is not essential should be left to the members of that particular community. They should decide what is essential, what is not essential. Because in a religion, and look at me carefully, she said, what is religion? It's a beautiful relationship that an individual has with his Lord, or an individual has with her Lord. There may be something superstitious in a religion, but you can't equate logic with religion. You can equate logic and objectivity with science. Science is logical, science is objective, but religion is not. So religion cannot be put under the same level of scrutiny as you put to science. In science, you have to prove a theory. In science, you have to prove a particular hypothesis. But that doesn't happen with religion. Religion is a matter between you and your Lord. So you can't be extracting rationality or objectivity from a religion, because that is not religion, that is science. Science is objective, science is logical. And she also criticized essential religious practices doctrine. Freedom of religion was meant to guarantee freedom to practice one's own beliefs based on inward association of man with God. And this was held by the court in the Ratilal Panachand Gandhi versus State of Bombay in 1954. The Supreme Court accepted that what is religion may not be superstition to somebody, may be superstition to somebody. And it is what you consider as your association with God, that is religion. And all that you consider as part of religion should be protected by the Constitution. Because what did Constitution say? Freedom of conscience. You have the fundamental right to decide what is your conscience. And once your conscience is clear, you have the fundamental right to profess, practice, and propagate your religion. This doctrine of essentiality it violates the autonomy of an individual. I have the autonomy to choose my conscience. And now the court is saying, we will decide your conscience. This violates some of the other landmark judgments passed by the Supreme Court recently, whether related to right to privacy, whether related to Section 377, whether related to adultery judgments, where Supreme Court has upheld that it is the autonomy of an individual which is linked with your privacy. I have the autonomy to choose my conscience, and it is my private part. It is intrinsic to my privacy. If right to privacy is my fundamental right, why should court decide what is essential to my religion, what is not essential to my religion? If right to autonomy is my fundamental right, why should court decide what is essential to my religion, what is not essential to my religion? Because what is religion is my inward association with God. And I have that conscience. Who is the court to decide what I should consider essential and non-essential? Then something else happened. When this Sabarimala case was decided by the court, when the court said women of all age groups may pray at Sabarimala, there were a series of protests in Kerala, some in favor, some against. But ultimately, a review was filed in the Supreme Court, because Supreme Court has the power to review its judgment as well. Review petition was filed. Supreme Court was told, Supreme Court, could you please review your judgment in Sabarimala case? Review is either accepted or rejected. That means when you file a review petition, the court will either accept this review petition or reject this review petition. On what grounds can the court accept this review petition? If a new fact has emerged, if new evidence has emerged, if an error has been pointed out in a judgment. For example, if the petitioners would have proven to the court that, my lord, you gave a judgment in the Sabarimala case on the basis of which you said women of all age groups may pray at Sabarimala. There is an error in this judgment. Why? Because previously you had said essentiality doctrine will not apply in this case. Or previously you had said that these rules are constitutional. Or new facts have emerged where we can prove through scriptures, where we can prove through religious text that throughout the history there was ban on the entry of women inside the sacred sanctum sanctorum of the Sabarimala temple. A new fact may be emerged. For example, a new fact that there are some temples where even men are not allowed, only women are allowed. So this is not discrimination on the grounds of gender. This is the religion created by that God. So this is where we have no rules. These rules are not man-made rules. These rules are created by God by looking at these religious texts. If, for example, new fact have emerged, new evidence has emerged, or you can point out an error in the previous judgment, the Supreme Court can accept your review petition. If not, it can reject. But this time, Justice Ranjan Gogoi was the Chief Justice of India. And Justice Ranjan Gogoi did something unusual, unprecedented, which has not happened in the past. He neither accepted this review petition, nor did he reject this review petition. What he did, he kept the review petition pending. Pending why? Because Justice Gogoi said that there are 3 other cases which raise similar issues. Unless and until we resolve those cases, we will keep this Sabarimala review petition pending. The court was asked, sir, what are these 3 cases? Said, number 1, in Islam also, women are denied entry inside the mosque and the dargahs. Just like in Sabarimala, women were not allowed entry inside the temple. There is a case pending before the court where Muslim women, they also want access to mosque and the dargahs. We will hear that case first. Till that time, we will keep Sabarimala review pending. Why? Because it raises similar question. There is another question. Female genital mutilation practiced by the Dawoodi Bohra community. Dawoodi Bohra is a sect in Shia Islam. Couple of days ago, they had a massive congregation which was addressed by Prime Minister Modi as well. Dawoodi Bohra, which is a sect under Shia Islam, they have a belief or they follow a practice. What is that practice? When a girl attains the age of 6 or 8, the clitoris of the girl is either completely or partially cut. Why? Because they have a belief that this clitoris, which is a private part, it's an unwanted skin on the private part. It is the source of all sins, and it should be either completely cut or partially cut. That's what they call female genital mutilation. Is this female genital mutilation violative of the dignity of a woman or not? That's the challenge before the Supreme Court right now. So it raises a similar issue as the ban on the women in Sabarimala case, because that you also alleged violates my dignity. Why am I not allowed entry inside the Sabarimala temple? We will first hear this female genital mutilation case because it raises a similar issue. Till that time, we will keep Sabarimala review pending. Third, there are Parsi women. If I'm a Parsi woman, I'm married to a non-Parsi. I am not allowed entry inside the fire temples of Parsi community. Why? Because I am married outside my religion to a non-Parsi. This matter is before the court. Whether this ban on a Parsi woman who married a non-Parsi, whether she can access the fire temple or not. This matter is before the court. So all these three cases raise similar issues as raised by the court in Sabarimala case. So till the time we decide upon the three other issues, we will keep this Sabarimala review pending. And then the court said, we will set up a larger bench to decide on various issues concerning the religion. What are these various issues? And right now, a 9-judge bench of the Supreme Court is hearing this matter. Will hear this matter. What are these issues? Number one, interplay between freedom of religion under Article 25 and 26 and other provisions, particularly Article 14. What is this interplay? Article 25 talks about individual rights. Article 26, which we will discuss now, it talks about group rights. In a sense, Article 25 is available to an individual. As an individual, I have the fundamental right to profess, practice, and propagate my religion. Article 26 gives right to my entire community, to all the Hindus, all the Muslims, all the Christians, all the Sikhs. What you can do, you can set up a religious institution. And this religious institution, how you want to manage, how you want to administer, how you want to make it function, that is your fundamental right. So now the court has said a 9-judge bench of the Supreme Court will have to decide what should be the interplay. In a sense, what will be given primacy? Which article of the Constitution, which fundamental right will have more primacy? Is it Article 14 or is it Article 25 and 26? In a sense, if Article 25 gives me the fundamental right to practice my religion, propagate my religion, what if there are some practices in the religion which violate right to equality under Article 14? What will be given precedence? Article 14 or Article 25? That this 9-judge bench of the Supreme Court has to decide. Question number 2. 9-judge bench of the Supreme Court. There is some restriction mentioned under the Constitution under Article 24. What are these restrictions? Subject to public order, subject to morality, subject to health. Your freedom of conscience, your freedom to profess, practice, and propagate religion can be restricted. How far can we impose restrictions in the name of public order, morality, or health? What is the sweep of this expression? What is the limit of this expression? For how far can we go and impose restrictions on the fundamental right to religion? That's for this 9-judge bench of the Supreme Court to decide. Another question. Review of essential religious practices. Now the court will finally decide whether we will be the authority to decide what is essential to a religion, what is not essential to a religion. Because Justice Kehar, Justice Nazir in Triple Talaq case, Justice Indu Malhotra in the Sabarimala case, they have categorically said, what is religion to you may be superstition to me. Religion may not be logical, yet it is religion. Religion cannot be equated with logic or objectivity because that is science. It's not for the courts to decide what is essential, what is not essential to a religion. It is for the members of that community to decide what is essential to their religion, what is not. So should this ERP continue, or should it be tweaked, or should it be modified, or should it be completely abolished? That is what this 9-judge bench of the Supreme Court will decide. But a bigger issue that this 9-judge bench of the court will have to decide is this. Do you know when this Sabarimala case was filed in the Supreme Court? Who filed this case? Activists, not the devotees of Lord Ayyappa. So if you go to Kerala, you ask the women in Kerala, at least the women I've spoken to, if you ask them, do you favor this judgment of the court? They say no. Why? We don't want to go to Sabarimala temple because we want to respect the sensibilities of the deity who is a celibate, who is a brahmachari. If they have said that we should not go inside the sacred sanctum sanctorum of the Sabarimala temple, We will abide by that. But then who approached the Supreme Court? Not these devotees who really believe in Lord Ayappa, but the activists who filed public interest litigation before the court. Now, this 9-judge bench of the Supreme Court will have to decide whether we should accept such petitions from devotees or also from those who are not the believers. Believers in the sense, can tomorrow non-Muslim women approach the Supreme Court and say polygamy in Islam should not be allowed? The court will now decide whether we can accept this petition challenging polygamy only from Muslim women or from other women as well. How far can we access and accept PIL from those who do not belong to that religious denomination? That is for this 9-judge bench of the Supreme Court to decide. So what is Article 25? Long story short, Constitution under Article 25 gives you a fundamental right. Gives you, me, everybody who is residing within the territory of India. Whether citizen or alien, doesn't matter. All those who are within the territory of India, they have twofold fundamental right. Freedom of conscience. An absolute innermost freedom. Absolute freedom to choose a religion. Absolute freedom to change your religion. Absolute freedom from religion as well. That is your fundamental right. But once your conscience is clear that you belong to a particular religious community, then you can profess that I belong to that religion. You can practice the features of that religion, the rituals of that religion. You can propagate that religion as well. But this freedom to profess, practice, propagate your religion comes under restrictions. What are these restrictions? In the name of public order. What are the restrictions? In the name of morality, in the name of health. For example, female genital mutilation practiced by the Dawoodi Bohra community. The court, even without going into whether it is essential or non-essential, because now the court will look into whether this female genital mutilation practiced by Dawoodi Bohra community, whether it is essential to their religion or non-essential to their religion. If it is essential to their religion, this practice will continue. If it is not essential to their religion, this practice will be discarded. Even without going through the route of essentiality or non-essentiality, the court will only look at, should only look at, on the grounds of health. Female genital mutilation affects the health of a girl child. This is not an unwanted skin which should be partially or completely cut. So in the interest of health, this practice should be declared unconstitutional without going through the route of essentiality or non-essentiality. Which means your right to profess, practice and propagate your religion can be restricted on the grounds of public order, health, morality and other provisions of this part. That means subject to other fundamental rights. That means Article 25 is subject to other fundamental rights as well. That means your Article 25 should not be violating other fundamental rights as well. And intrinsic within Article 25 is reform. Reform in the sense, all Hindu temples should be thrown open to all sections and classes of Hindus. But then basis the judgment of the court in Shirur Mutt 1954, now the court will have the power to decide what is essential and what is not essential to a religion. For that, we have discussed triple talaq case. We have discussed the mosques case in Ismail Faruqi. We have discussed the Shabrimala case. And now this 9-judge bench of the Supreme Court will hear the matter and look at and ask and answer questions surrounding all this controversy. Whether there should be essentiality doctrine or not. What should be the sweep of this expression, public order, morality and health? Can we accept PILs from those who do not belong to that religion? And what will be the precedence? If Article 25 is practiced, but Article 14 is violated, what will be given primacy? Who will have an upper hand? Article 14 or Article 25? That is for this wider, larger 9-judge bench of the Supreme Court to decide. Now, if you have any questions, please let me know. Then we will jump to another part. The 9-judge bench has not decided yet. What about review of Shabarimala case? Were the other cases solved or not? No, these cases were not solved yet. The matter is still pending before the court. I will give you a break. As of now, women are permitted in Shabarimala or not? In fact, when this verdict was given, then some women, they tried to enter the Shabarimala because now they are allowed. But they were not given police protection by the Kerala government. Basically, they were not facilitated entry inside the temple. These women approached the Supreme Court. My lord, see what has happened. You gave us the permission to enter the temple, but we are not allowed. We are not given police protection. The Supreme Court itself said that it's a sensitive matter. Please have patience. Don't worry. Which means you can say compliance with a Supreme Court order is not optional. It is not a matter of choice. In fact, this time the Supreme Court is committing contempt of itself. The Supreme Court, ideally, technically, legally, should have asked the police, give them the protection so that they're allowed to pray at the Shabarimala temple. If we strictly go according to the law, according to the rules. But the court basically smiled at the petitioners and said, what is the hurry? Don't worry, we are hearing this matter. Even if the review petition is pending, review petition is neither accepted nor rejected, it is pending. That means right now the law of the land is women of all age groups should pray at Shabarimala. They should be allowed to pray. But even then the women don't go there because the police is not allowing. Okay, let's take a break. Let's meet at 7:50 and discuss other fundamental rights. See you on the other side of the break. Shall we continue? Okay. Now let's look at Article 26 of the Constitution. Article 26 says the same thing. Subject to public order, morality, and health. What? Every religious denomination, every religious community, Hindus, Muslims, Christians, Sikhs, Jains, Parsis, Buddhists, they will have the fundamental right to establish a religious institution, to maintain that religious institution, whether it is to promote your religion, whether it is to propagate your religion, or whether it is to do charity, whether it is to help your community get access to hospitals, healthcare facilities. You have the fundamental right as a religious denomination, which means Article 26 is a group right available to a group. Article 25 is an individual right available to an individual. As an individual, you have the fundamental right to conscience and freedom to profess, practice, and propagate your religion. But for a group, for the entire community, whether Hindus, Christians, Buddhists, Jains, Parsis, Sikhs, Jews, you will have the fundamental right to establish an institution, manage an institution, administer an institution, whether this institution is for religious purposes, for the propagation of your religion, or whether it is to do charity, whether it is for charitable purposes. But even this fundamental right is subject to public order, morality, and health of the society. You can acquire property, you can dispose of property, you can own and acquire movable as well as immovable property. What is a movable property? Money, cash. What is immovable property? The buildings that you own. And even here, the state, what it can do, it can restrict secular activities related to religion. What are these secular activities related to religion? For example, there is a religious institution, TTD, Tirumala Tirupati Devasthanam. It is the fundamental right of a religious denomination, Hindus, for example, to establish this religious institution called TTD. And you have the fundamental right to manage affairs, but in matters related to religion. What are these matters related to religion? When the mosque is open for public, that this mosque authority will decide, that this religious institution will decide whether we will keep this mosque closed for some time and then open it for those who want to pray. That's for this religious institution to decide. In TTD, we will give you laddu for all those who want to pay obeisance at this temple. Can the state tomorrow say, no, instead of laddu, you should give jalebi or rosagola, or you should give barfi? That the state cannot interfere. But is this laddu fit for human consumption? That the state will regulate. That means this laddu may be certified by Food Safety and Standards Authority of India, whether it has some ingredients which are not carcinogenic, which are not cancer causing, whether it is fit for human consumption or not. Because that is a secular activity. Secular activity in the sense, food is a secular activity. This food should be fit for human consumption. It is not related to your religion. What is related to your religion is that laddu will be given. When the laddu can be given, when the DT is open for public darshan, when the DT can be fed, when the DT can be given a bath, that's for this religious institution to decide. State will not interfere. But state will interfere if it is related to the secular activity. For example, if the money which you are donating to a religious institution, whether that money is spent well or there is corruption there, the state can interfere. whether this laddu is fit for human consumption or not, that the state will determine. Similarly, priesthood is a secular activity and can be regulated by the state. Priesthood, in the sense, this was said by the Supreme Court in Professor Bhim Singh versus State of Jammu and Kashmir. What was said? What the priest can chant, what are the hymns that priest can sing, what are the shlokas that the priest can sing, this is determined by that religious institution. State will not interfere. State cannot say that in a mosque you should sing Gita or Ramayana. The state cannot say that in a temple you should read Quran. That the state will not interfere. But the state can interfere who is going to be the priest. Priesthood, which was primarily restricted to the members of the Brahmin community. But now the state can appoint priests to a religious temple. That's how members from the Dalit community have been appointed as priests in Tamil Nadu and in Kerala, which means priesthood is a secular activity, can be regulated by the state. But what the priest can chant, that the state cannot interfere. Similarly, in the interest of the health of the society, for example, during COVID-19 lockdown, mosques, temples, gurdwaras were closed. Can you approach the Supreme Court? My lord, my fundamental right has been violated. I am a religious body, for example, Gurdwara Prabandhak Board, and we are being forced to close down the Gurdwara. This is violating our fundamental right under Article 26 of the Constitution. The Supreme Court will ask the government, have you told them not to open the Gurdwara? The state will say yes. On what grounds? Are you violating their fundamental rights? No, sir. This fundamental right is not absolute. Because in the interest of the health of the society, we can restrict your fundamental right. If we open up our religious places, people will come, virus will spread. For the interest of the health of the public, this fundamental right can be restricted. So the difference is Article 25 is related to an individual right. Article 26 is a group right available to all the religious denomination. That you have the fundamental right to establish an institution, manage an institution, administer an institution, acquire property, immovable property, movable property, and whether you are establishing this institution for religious purpose or charitable purpose, that is your fundamental right. But this fundamental right is subject to public order. This fundamental right is subject to the morality of the society. This fundamental right is subject to the health of the society. And this is where the state can regulate the non-religious functions of an institution. And those non-religious functions are what we call secular functions. For example, matters related to money, matters related to whether this food which is given is fit for human consumption or not. That is Article 26 of the Constitution. Article 27 lays down a secular India. Secular India in the sense, the term secular was added to the Constitution by 42nd Constitutional Amendment Act, 1976. Does that mean that India became secular in 1976? No. India was secular even before that. How? Article 25 is the secular identity of India. All the religious communities, all the individuals in India, they have the fundamental right to practice their religion. That it's not saying that you can practice only one religion and not others. You can practice any religion. That's your fundamental right, which means no discrimination on the grounds of religion. That's secular. Similarly, Article 15, there can be no discrimination on the grounds of religion. That's the secular identity. Article 16, in matters related to public employment, there can be no discrimination on the grounds of religion. That is the secular idea of India. But even more pronounced is the secular idea of India when we look at Article 27 of the Constitution. And what is Article 27? Look at during Mughal period. Akbar tried to abolish it. Aurangzeb started it again. What was it? Jizya. What was jizya? Tax. Tax for whom? Non-Muslims. So non-Muslims under the Mughal Empire, if you want safety, if you want security, you have to pay tax to the Mughal Empire. So tax for a specific religion that was imposed prior to the commencement of the constitution, that cannot happen in India now because that is prohibited under Article 27. Under Article 27, the state cannot impose tax for a particular religion. That this tax is only applicable on Muslims, only applicable on Hindus. That cannot happen. That's number one. Number two, tax cannot be used for the promotion and propagation of any particular religion. That means whatever tax we are imposing on the people, whatever money is being raised and generated, this money cannot be only used for one particular religion, cannot be used for maintenance or promotion of any one particular religion. So if the state is giving funds, let's say for example, for constructing a Hajj house, the state will still use funds for constructing something beautiful in Varanasi related to the Hindu community. For many years, some years ago, there used to be subsidy provided to the Muslims who want to go on a Hajj pilgrimage. Subsidized rates for food, subsidized tickets, subsidized hotel stay in the twin cities of Makkah and Medina. But now that Hajj subsidy is not given. But the point is, can state use its money for the promotion of any one particular religion? If it is given for those who go on a Hajj, it is also given to those who go on Kailash Mansarovar Yatra. It is also given to those who want to go to Israel and want to visit the holy site in Jerusalem. So that lays down the identity of the secular India under Article 27 of the Constitution. No person shall be compelled to pay any tax, the proceeds of which specifically be appropriated for the promotion or maintenance of any particular religion. That cannot happen because that is prohibited by Article 27, and that lays down the secular identity of India. That's Article 27. Article 28, it raises one question and answers it. What's the question? Can religious instruction be imparted in educational institutions? Can religious texts, religious scriptures, religious instruction be imparted in educational institutions? For that, the Constitution talks about 4 different kinds of educational institutions. Which are these? Institutions wholly maintained by the state. Which is a state? State under Article 12 of the Constitution. That means those institutions which are created by the central government, those institutions which are created by the state government. For example, the schools that we have, the government schools, the government colleges, the government universities, the government engineering and medical colleges, there no religious instruction can be imparted. Why? Because the state is secular. No religious instruction can be imparted, no religious text can be taught. But then there are some institutions which are recognized by the state, and there are some institutions which are receiving aid from the state. Both these types of institutions are basically private institutions. But there is a private institution which is recognized by the state. How? Private engineering college recognized by All India Council for Technical Education, which is a state under Article 12. A private university recognized by University Grants Commission, which is a state under Article 12. A private law college recognized by the Bar Council of India, which is a state. A private agricultural college recognized by Indian Council for Agricultural Research, recognized by the government, recognized by the state under Article 12. Similarly, there are institutions which are receiving aid from the state, and that is what we discussed in Article 15. There are some private institutions which are aided by the state, which are receiving funds from the state. Here, religious instruction can be imparted but cannot be made compulsory. In private colleges, in private universities, recognized by the state, recognized or receiving aid from the state, their religious instruction can be imparted, religious scriptures can be imparted, but cannot be made compulsory. Those who want to adopt can, those who don't want to, they cannot be forced. But then there are some schools, for example, Khalsa schools, for example, convent schools, where religious instruction is imparted and is made compulsory as well. If you are studying in a convent school, you will be taught about Christianity. You will be asked to sing praises about Christianity. You will be forced as well. That is mandatory for you. Similarly, if you're studying in a madrasa established by the religious Muslims, similarly, if you are in a mutt established by the Hindu religious institutions, their religious instruction can be imparted, can be made compulsory as well. Because these are set up by religious institutions themselves. These are set up by religious charitable institutions themselves. This is where religious instruction can be imparted and can be made compulsory as well. But sir, what about recent developments where, sir, in Madhya Pradesh, the chief minister says Gita will be taught, Mahabharata will be taught, Ramayana will be taught. Is that not violative of Article 28 of the Constitution? No. Why? Because the intention of the government is not to give religious instruction. The intention is to come out with some moral stories. So basically, moral science is taught by looking at some of the moral stories through which an individual can become a better individual. Those moral stories are extracted from these religious texts, and that is how moral education is provided, moral science is provided. Religious instruction is not given. Under that logic, this order by the Madhya Pradesh government, by the Haryana government, to teach the moral stories of Mahabharata, Gita, Ramayana, these are not unconstitutional. And that completes our Article 25 to 28. We had to spend more time on Article 25, 26, 27, 28 are mostly relevant for your prelims examination. What is the combined crux of this right to religious freedom? It comes under a chapter of fundamental rights under Part 3 of the Constitution. Article 25 gives you twofold fundamental right, freedom of conscience and freedom to profess, practice, and propagate your religion. But you would know this fundamental right is not absolute because exceptions are there, reasonable restrictions are there. In the interest of public order, in the interest of morality, in the interest of health, and subject to other provisions of Part 3 of the Constitution, subject to other fundamental rights under Part 3 of the Constitution. And there the Supreme Court has taken upon itself, the judiciary has taken upon itself to decide what is essential to a religion, what is not essential to a religion. Clear? Then Article 26 talks about rights given to a group. All the religious denominations, all the religious communities, they will have the fundamental right to establish, manage, and administer an institution. Whether this institution is for propagating your religion or whether this institution is for charitable purpose. That is your fundamental right. But even this fundamental right comes under restrictions. In the interest of public order, in the interest of health, in the interest of morality. That means the state will interfere, will restrict these group rights under Article 26, but by regulating the secular activities of a religion. When the temple is open for darshan, the state will not interfere. When the deity is to be given bath, the state will not interfere. When the deity is open for darshan, the state will not interfere. What deity will be fed, state will not interfere. But state will interfere. Who is going to be the priest of that temple? The state will interfere regarding the management of the money. The state will interfere regarding the food that is given. What is the food given? The state will not regulate. But whether that food is fit for human consumption or not, state will interfere. And Article 27, a simple fundamental right which regulates or which lays down secular identity of India, which means tax cannot be imposed for any particular religion. For example, tax in the form of cess. What is a cess? Tax for a specific purpose. For example, you go to a restaurant, apart from the money that, apart from the items that you have consumed, you have to pay tax as well. For example, Swachh Bharat cess. For example, health and education cess. For example, previously Krishi Kalyan cess. Whatever money is generated through this cess will be used for that particular purpose. That means whatever money we have raised through Swachh Bharat cess will be used only for the Swachh Bharat Abhiyan. Whatever money we have raised from health and education cess will be used only for health and education. Can the state tomorrow impose a cess? You go to a restaurant, you consume items, and then a cess will be imposed called Ram Temple cess, which means whatever money is generated from this cess will be used for the construction of the mega Ram temple at Ayodhya. That cannot happen because tax for a specific purpose, for a specific community, for a specific religion cannot be imposed by the state. And whatever money is raised by the state through taxation can be used for the promotion and maintenance of all religions, cannot be used for a particular religion. If it is used for a particular religion, then we are not secular. If it is used for all religions, then we are secular. That's Article 27. But can the religious instruction, religious scriptures, religious texts be taught in educational institutions? For that, we have four broad type of institutions. Institution number one, which is wholly maintained by the state. That means state institutions, government colleges, government schools, government universities. Neither can religious instruction be given, nor can it be made compulsory. Why? Because the state is secular. But then there are private institutions which are recognized by the state. There are private institutions which are receiving aid from the state, funding from the state. Their religious instruction can be imparted because it's a private institute. It's not a state under Article 12, but cannot be made compulsory. Why not compulsory? Because the state is recognizing you and the state is secular. Because the state is funding you, aiding you, and the state is secular. But then there are educational institutions which are created, established by religious institutions themselves, religious communities themselves, charitable institutions themselves. For example, Khalsa schools, for example, convent schools, for example, mutts, for example, madrasas. Their religious instruction can be imparted and can be made compulsory as well. Even if these madrasas are recognized by the state, these convent schools are recognized by the state, these convent educational institutions are recognized by the state. That is Article 28 of the Constitution. But that does not mean that we cannot look at the moral stories from some religious texts and impart those moral stories to the students, impart moral education to the students. That is something that can be allowed. Clear? Article 20, according to this, state can establish a temple and use public texts. When did I say that? I never said that. I'm only accountable for what I say, not what you understand by that. Great. Now, there can be questions, for example, sir, but whatever you are saying is violated on the ground. Saraswati Puja, Lakshmi Puja, various puja festivals, they are organized in a big way by educational institutions, and the government is forcing them that no, you have to do it. Is that not unconstitutional? Constitution does not allow you to murder somebody. Even then, murders take place. Constitution does not allow you to rape somebody. Even then, the incidents of rape keep on rising in India. So we can only say what Constitution has said, promised. But if there is a violation of the Constitution, for that we have the judiciary. And if the judiciary is independent, judiciary will strike down all those unconstitutional things. That's a separate matter. But what Constitution has written, said, explained, that we are discussing now. Ram Temple government money is used. It is not violation of Article 27. Now, Ram Temple is constructed not out of public money. There is a separate institution responsible for that, which is collecting money from Hindus through donations. The state is not giving money to the for the construction of Ram Temple, so it's not violation of Article 27. I just gave an example. The example was if this cess is imposed for the construction of Ram Temple, that is unconstitutional. There is no cess for the construction of Ram Temple. It was only an example. Got it, Shalu? Okay. Now let's look at Article 29 and 30. These come under cultural and educational rights. Article 29 and 30, these specifically deal with citizens. That is why when we discussed fundamental rights, we discussed citizenship as well. I told you that there are 5 fundamental rights which are exclusively available to citizens. Article 15, 16, 19, 29 and 30. Article 29, it talks about any section of citizens residing anywhere within the territory of India. If they have a distinct language, script, or culture of their own, and they want to preserve that culture, they will have the fundamental right to conserve that culture. And this is where we come across a phrase known as unity in diversity. India is united despite its diversity. So diversity can be religious diversity. People of different religions are inhabiting in India. Caste diversity. People of different castes are inhabiting in India. Linguistic diversity. People of different languages are inhabiting in India. Every section of citizens in India residing anywhere within the territory of India, if they have a distinct language, script, or culture of their own, and they want to preserve that culture, they have the fundamental right to preserve that culture. What are these examples of different cultures? For example, tribal culture. I'll give you 3-4 examples of what sort of culture is protected under Article 29 of the Constitution. In some tribal communities, we see marriage by capture. For example, Nagas. If there is a boy who likes a girl, what does this boy do? Rides a horse, basically kidnaps the girl, and then marries her. This is called marriage by capture. In mainland India, in mainstream India, in the rest part of the territory of India, this would be kidnap, this would be rape, this would be outraging the modesty of a woman. This is a criminal offense. But this is the tribal culture in Nagas. This is protected under Article 29. So discrimination against man. What about a girl? What if a girl likes a boy? That is what is known as marriage by intrusion. The girl likes a boy, she packs her belongings and then forcefully enters and intrudes into the house of the boy. stays there, convinces the boy, and over a period of time, they get married. So, this is marriage by intrusion. This is culture and protected under Article 29. Some Berhor tribe in Jharkhand, Odisha, where, for example, the father in law passes away. What is this guy doing? Marrying the mother in law to provide protection to the mother in law because her husband has died, father in law has died. This is culture protected under Article 29. Similarly, there are some tribes where the girl, before she marries the boy, she marries the grandfather. There is no illicit sexual interaction involved here. But this is just the kind of protection that you have got from this grandfather will be given by this husband as well, future husband as well. This is incest in mainland India. This can be called incestuous relationship. But this is a culture protected in some tribal communities, protected under Article 29 of the Constitution. If you want to preserve your language, that's your fundamental right. If you want to preserve your culture, that's your fundamental right. And preservation of language means we will discuss in Schedule 8 of the Constitution that there are 22 languages which are called as official languages, which are called Indian languages. For example, there is a state, West Bengal, for example. There, a language is spoken. This language may be Kurk. Kurk is a Dravidian language. This language may be spoken. But if the members of this community, every section of the citizen residing anywhere in the territory of India, if they want to preserve that language, they have the fundamental right to preserve that language. And what they can do, they can also agitate. You can agitate and ask the state government that please include our language as the state language. They have the fundamental right to do that. And Kurk, 5 years ago, was declared as another official language of West Bengal. Long story short, what is Article 29? Specifically, a fundamental right for the citizens. Any section of citizens residing anywhere within the territory of India, if you have a distinct language, script, or culture of your own, and you want to preserve that culture, you have the fundamental right to conserve that culture. And this fundamental right includes you have the right to agitate, you have the right to organize protests, you have the right to organize dharnas for the conservation of your culture. None of you asked me this question when we discussed Article 15. What is Article 15? There can be no discrimination only on the grounds of sex. You did not ask me this question, sir. Why is it that we have separate schools, separate colleges in India for men and women? So after reading Article 15, you will knock the doors of a women's education college principal. Give me education. I'm a boy. Sir, I can't give you education. This is a girls' college. You can't violate my fundamental right because I have fundamental right against discrimination. Only on the grounds of sex, you cannot discriminate against me. The principal will be shocked, surprised. What do I do? Start flipping through the Constitution and will say, no, but there exists Article 15, Clause 3. The state can make special provision for women. And that is why there is this women's college. Said, no, the real answer is, the most appropriate answer is Article 29, Clause 2. No citizen shall be denied education in any educational institution, shall be denied admission in any educational institution only on the grounds of religion, race, caste, language, or any of them. That means there can be discrimination on the grounds of sex. There can be discrimination on the grounds of place of birth. There can be discrimination on the grounds of residence. But no citizen can be denied admission in any educational institution only on the grounds of religion, race, caste, or language, or any of them. Does that mean in India, we have a minority language? Is there any language in India which is a minority language? Tulu, spoken in Karnataka. Parsi, Nitesh says lots of. Sanskrit. There is no such thing as minority language. No language is a minority language in India. What we have instead, we have a set of endangered languages. And what is an endangered language? For that, we have a definition by UNESCO. What is the definition? Any language spoken by less than 10,000 people. Any language spoken by less than 10,000 people in India will be categorized as an endangered language. Endangered, that means there is a danger that if this language is spoken by less number of people, tomorrow it will go even lesser, and then over a period of time, it may become extinct as well. Then this language will disappear from India. Those languages which require protection, which require preservation, which require assistance, so that these languages do not become extinct, those languages spoken by less than 10,000 people, they are called endangered languages. But there is no such thing as minority language. But what we have minorities. Who are these minorities under Article 30? Minorities, whether based on religion or language. All minorities, whether based on religion or language, what they will have the fundamental right to establish and administer educational institutions of their choice. Choice can be medical, engineering, law, agriculture, smart schools, kids schools, play schools, any school. You will have the fundamental right to establish, manage your educational institutions. But this term minorities is not defined in the Constitution. Who are these minorities? It is not defined in the Constitution. When matter was debated by the Constituent Assembly, Dr. Ambedkar was asked, but who are these minorities for whom you want to give protection under Article 30 of the Constitution? He said all minorities, whether based on religion or language. He said, can you give an example? For example, Marathis who migrate to Tamil Nadu. That means all those Marathis who are in Tamil Nadu, they are minorities in Tamil Nadu. Why? Because they speak Marathi language, which is not spoken by the majority of the people in Tamil Nadu. So they become linguistic minorities in Tamil Nadu. And religious minorities, all these minorities, whether based on language or religion. That means language is not minority. People are linguistic minority. Marathi is not a minority language. But Marathi speaking people in Tamil Nadu, they are linguistic minorities. And these minorities, whether based on religion or language, they will have a fundamental right. What is the fundamental right? You can establish and administer educational institutions of your choice. Choice can be anything. Professional educational institute, technical educational institute, primary school, secondary school, higher educational institution. That is your fundamental right. But how is it different from others? We have a set of 6 religious minorities in India, recognized by National Commission for Minorities. Which are these 6 religious minorities? We have Muslims, Christians, Sikhs, Buddhists, Jains, and the last one added were the Parsis. These 6 religious minorities, what they have the fundamental right. What you can do? You can establish, you can manage, you can administer your own educational institutions. What is the protection? Protection number 1, no caste-based reservation. That means in other educational institutions, whether government or private, whether aided or unaided, there is reservation for SCs, STs, OBCs, and economically weaker sections of the society. But those educational institutions established by the minorities, they will not have to follow this caste-based reservation. No reservation on the grounds of SCs, STs, OBCs, or EWS. That is why there are various communities in India which are demanding minority status that make us minority, so that when we establish an educational institution, we don't have to follow caste-based reservation. Not just that, these educational institutions can reserve up to 50% seats for their own community. And this was said by the Supreme Court in St. Stephen's College versus University of Delhi, 1992. The Supreme Court said these minority educational institutions, if there is an educational institution set up by Christians, for example, they can reserve up to 50% of their seats for Christians. If there is an educational institution set up by Muslims, they can reserve up to 50% of the seats for its own community. That is why Lingayats in Karnataka, they have been demanding minority status. Why? Because if they establish educational institution, they don't have to follow caste-based reservation. And in fact, they can reserve up to 50% of seats for their own Lingayat members, which means they want to promote, protect, uphold, and they want to give liberty to their own community members. These minority educational institutions, they can also decide their own syllabus, fee structure. Long story short, they have the autonomy to run their institutions. That's their fundamental right. Fourth, even important fundamental right. Right now, we have a law called Land Acquisition Law, which was passed in the year 2013. 2013. So that is basically called a right to rehabilitation through land acquisition. In a sense, if this is the land which is in an urban area, and this is the land which is in the rural area, if the state wants to acquire this land which is in urban area, then the state will have to pay compensation to the owner, which is 2 times the market rate. If the market rate of this land is 1 crore, the state will have to pay compensation which is twice, 2 crores. But if this land is in the rural area, the state will have to pay compensation which is 4 times the market price. If the state wants to acquire this land, it has to pay a very good compensation. But this compensation started in 2013. Prior to that, there was a law known as Land Acquisition Act of 1896. Under that, there was no need for a guaranteed compensation. Guaranteed compensation, fair compensation was not given to those whose land, whose property was acquired by the state. But the fundamental right given to minority educational institution, right at the time of the commencement of the constitution, was if the state wants to acquire the property of a minority institution, wants to acquire land of a minority institution, it has to pay fair compensation. And as it has to pay compensation in such a manner that if you have snatched that land, it should not limit the objective of that institution. What is the objective of that institution? To provide educational institution to their own community member. So if you are snatching their land, which is in Pune, and you give them land which is in Satara, it is not fair compensation. Why? Because then you are restricting access to education for their own community. You have to pay them compensation in the form of money so that they can buy land in same Pune. Or you have to give them compensation in the form of a land, and this land should also be in Pune. That fair compensation is a fundamental right available to minority educational institutions. But in 1978, right to property was deleted as a fundamental right. But this right to property is still a fundamental right for minority educational institution. But then the matter went to the court. My lord, I have a question. I said, what is the question? Sir, Hindus are in a minority in Nagaland. Hindus are a minority in Punjab. Hindus are a minority in Jammu and Kashmir. Hindus are a minority in Meghalaya. Can Hindus in these states are also determined as religious minorities so that they can set up educational institutions? So that in these educational institutions, there is no caste-based reservation. There is reservation for own Hindu community, and they can decide their own free structure, syllabus, so on and so forth, autonomy to run that institution. Or should it be that we define minorities pan-India, throughout India? Or should we decide upon minorities based on individual states? Because if you look at the pan-India structure, Hindus are in a majority, more than 80% of the population. But in Nagaland, they are a minority. In J&K, they are a minority. In Punjab, they are a minority. In Meghalaya, they are a minority. So can Hindus in these states have the protection under Article 30? The court issued notice to the central government, asked the central government, what is your take on this matter? And this case is still pending. So right now the case is pending. Should we decide minority based on national picture, or should we decide minority based on individual states? That is the question that Supreme Court will have to answer very soon. But that is Article 30 of the Constitution. What is Article 30? All minorities. And who are these minorities? Whether based on religion or language. What is the protection they have? They have the fundamental right to establish educational institution, that too of their choice. And the state, when it is providing funding, when it is aiding educational institutions, for example, the state has said, state under Article 12, that we will provide 1,000 crore to educational institutions so that these educational institutions can become smart schools. That means we will give them money so that they can set up internet facilities in schools, so that they can set up smart boards in the schools, so that these smart boards are connected to the internet, so that through audio visual aids, we are providing education to the kids. That means the state has to provide 1,000 crore to educational institutions to convert these educational institutions into smart schools. Here, the state cannot discriminate whether these educational institutions are minority or not. That means it has to pay this compensation, it has to pay this funding, it has to grant this aid to all institutions, including minority educational institutions. That means the state shall not discriminate in granting aid to educational institutions on the ground that it is under the management of the minority. Even for minority educational institutions, aid should be given by the state. That is the protection under Article 30 of the Constitution. Any questions as of now? Sir, state will fund these institutions? Yes. Why is there so much pending cases in the Supreme Court? Because Supreme Court does not have the enough time. Sir, how will the state maintain all religions without using public money? The state will use public money, but for the promotion and protection of all religions, not any particular religion. Okay. Then we have Article 31, which was repealed in 1978. We have Article 31A, Article 31B, Article 31C. All these we will discuss in DPSP. in Directive Principles of State Policy. So today we will discuss Article 32 of the Constitution, because after Article 30, 31 appears, but 31 we will discuss in DPSP. We'll now discuss Article 32 of the Constitution. Something happened in 2016. It was November 8, I think, 2016, 8 o'clock in the evening. Mr. Modi addressed the nation. The Prime Minister addressed the nation and said, Mitro, beginning midnight, all the 500 and 1000 denomination notes will cease to be legal tender. That means these 500 and 1000 denomination notes were demonetized. If you have 500 and 1000 notes, you cannot use them to buy anything. It will not have any legal value. It will be like a worthless piece of paper. That's what Mr. Modi said. Beginning midnight, all these 500 and 1000 denomination notes will be worthless piece of paper. We have a chapter called Fundamental Rights under Part 3 of the Constitution. Right to equality, Article 14, 15, 16, 17, 18, 19, 21, 22, 29, 30. All these fundamental rights are given to you by the Constitution. What if these fundamental rights are violated and there is no remedy available to you? So Constitution gives you right to equality, but it does not tell you what you should do if it is violated. What is the remedy available to you? Constitution gives you freedom of speech and expression, but in case it is violated, Constitution does not tell you where you have to go. That means all these fundamental rights provided by Part 3 would be demonetized. They will be worthless piece of paper. State will say, you have freedom of speech and expression. So what? You have right to life. So what? I will still snatch it. I will still snatch it. If Constitution has given you, go back to the same Constitution and ask for a remedy from that Constitution. There is no remedy. If there was no remedy, then all these fundamental rights are meaningless, worthless piece of paper. They will just be paperized. They're only there decorized on a piece of paper, but they have no value. They have value because we have a remedy provided by the Constitution under Article 32, which is called right to constitutional remedy. Remedy is provided by the Constitution. In case your fundamental rights are violated, directly approach the Supreme Court under Article 32. And Supreme Court is the protector, the guarantor of your fundamental rights. Supreme Court is the guardian of the Constitution. We will protect your fundamental rights. And the beautiful thing is, even this remedy itself is a fundamental right. Sir, what's the difference? Listen to me carefully. If Constitution would have said you have Article 14, 15, 16 up to 30, you have these fundamental rights. Constitution would have mentioned only this. And to enforce these fundamental rights, to see if these fundamental rights are violated or not, Parliament will make a law and decide how these are to be enforced. Parliament will give you the remedy. What will happen in case these fundamental rights are violated? Tomorrow, Parliament would have given you the remedy. Parliament would have snatched it as well. But the Supreme Court did not. But the Constitution did not leave it to the Parliament. Constitution in the Constitution itself, that too in the Fundamental Rights chapter itself, has said that we are giving you the remedy. And this remedy itself is a fundamental right, which means Parliament cannot snatch it, Parliament cannot delete it. That is why Dr. Ambedkar was asked, what do you think is the most important of all fundamental rights? We have a list of fundamental rights. What do you think is the fundamental of all fundamental rights? Dr. Ambedkar said it is Article 32, which is fundamental of all fundamental rights. Because without Article 32, you don't have any remedy. All these fundamental rights will be merely paperized, would be worthless piece of paper. And what are these remedies? The court will issue various writs Through these writs, the court will protect your fundamental rights. Habeas corpus, mandamus, certiorari, prohibition, quo warranto. It is through these writs, it is through these directives that the court upholds, protects, and guarantees you the fundamental rights. Let's look at all these writs one by one. First up, what is habeas corpus? In literal terms, it means show me the body. What does that mean? Here is an individual detained by the state. Here is an individual detained by the state, but detained arbitrarily. I did not commit any crime. I'm teaching you right now. And most of you appreciate this teaching as well. You understand this. Suddenly, the police comes knocking at my door and arrests me. That means the state has violated my right to life and personal liberty. That too arbitrarily, without any logic, without any rhyme and reason. You or my family members or my colleagues, you will approach the Supreme Court. Supreme Court, we have a petition. Which petition? Writ petition. What writ petition? Habeas corpus. Why? Because our friend, our colleague, our son has been wrongly detained by the police. The court will ask the police, show me the body of this individual. Not dead body, real body, alive. Show me the body of this individual. Bring him before the court. Basically, produce him before the court so that the court can ask you, Mr. Sarmad, why were you arrested? Sir, I don't know. Really? Absolutely. I have no idea whatsoever. I was teaching. In fact, I was teaching habeas corpus when they arrested me. Said, really? Police, why did you arrest? Said, because he's accused of murder. Okay. Where is the evidence? We will produce the evidence, sir. Where is the case diary? Sir, what case diary? You have to mention in the case diary the time and date of his arrest. Did you mention it? No, sir. Did you produce this individual before the court within 24 hours of the arrest? No, sir. What are you doing? How dare you violate the fundamental right of my client, my citizen? I am the protector, the guardian of this fundamental right. So, Mr. Sarmad, you are set free. Habeas corpus is issued. This writ is issued. You are set free. That means this habeas corpus comes to your rescue when your right to life and liberty has been snatched by the state. Go to the court will uphold your fundamental rights. But the problem is, the violator may not be the state. The violator may be a private individual. Private individual in the sense, one habeas corpus has been issued recently. What is that habeas corpus? Two girls. They were in a consensual adult relationship. Lesbians, they were together. The family, they're not in agreement. Now, one girl, she has been illegally detained by her family. That means this case, this time the violator is not the state. But we have discussed in Article 12 that all these fundamental rights are claimed against the state. If the state violates your fundamental right, and what is that state? The state under Article 12. But this time, who has detained you? A private individual, your father, your mother, your family, which is not a state under Article 12. Her partner has approached the Supreme Court. Supreme Court has previously also said, multiple times also said, that fundamental right is so important, particularly this right to life, that we will not go into whether the violator is a state or a private entity. Whether the violator is a state under Article 12 or a non-state entity, it doesn't matter. We will protect you. Now the court has issued the writ of habeas corpus. Ask the father of that girl, produce that girl before us so that we can tell her, beta, were you staying at your home out of your own will, or were you illegally controlled by the father? If by the father, we will set you free. Why? You want to marry? Right to marry is a fundamental right under Article 21. But sir, this is a same-sex marriage. Oh, same-sex marriage we have still not legalized. So you can't marry right now, but you can stay together because right to love is a fundamental right under Article 21. Homosexuality is not a crime. That is habeas corpus. So habeas corpus in simple terms means show me the body, which means if a fundamental right to life has been violated, whether the violator is the state or a private individual, doesn't matter. Go to the court. The court will come to your rescue. That's number one. Number two, there is a thing known as locus standi. What is locus standi? For example, I'm teaching polity right now. You're all happy. Sir teaches well. At least we understand. Sir makes it interesting. At least we understand. Suddenly, there will be a third person who is not our student. He will come and say, change the teacher. Said, why? Because I don't agree. Said, why? I don't agree. Change the teacher. But what is your locus standi? How are you connected? If the students who are attending the class right now, if they have a complaint, I will step away and someone else will start teaching Indian polity. No issues whatsoever. But you are not related to this class. You're not a student of Byju's. You're not a student of the live class. How can you say that this teacher should be changed? What is your locus standi? How are you connected with this case? What is your connection with this case? Similarly, when a case is normally filed in the court looks at locus standi. So you have filed this case, which means your rights should have been violated. Have your rights been violated? Okay, you can approach the court. Someone else cannot approach the court on your behalf. That means you have a dispute between, there is a dispute between you and Byju's. You can approach the court. There cannot be Mr. Adani who will come and file this case on your behalf. My lord, here is the petition between student 1 and Byju's. Said, but who are you? I am Adani. Who are you? Sir, I used to be the richest person in Asia. Now you are not? No, sir. Why? Said, because of some short sellers allegations, conspiracy against India, conspiracy against nation. I am a patriotic individual. You're all patriotic. You are brilliant. We respect you. But you don't have a locus standi. How are you connected with this case? Your case is dismissed. If this student files a case, we will accept. But Supreme Court said habeas corpus is so important that we will not go into locus standi at all. That means if somebody approaches us and says someone else's right to life has been violated, not yours, someone else's, we will still accept this petition because we will not go into the question of locus standi. We will not ask, what is your case? How are you connected with this individual? Are your fundamental rights violated or not? No, locus standi does not apply. And this is what happened when Dr. Farooq Abdullah was detained by the state, when Article 370 was diluted in 2019. Another member of the parliament, Mr. Vaiko from Tamil Nadu, approached the Supreme Court and filed a petition of habeas corpus. The court did not ask him, who are you? How are you connected with Farooq Abdullah? Are you his son, friend, daughter, what? Partner? No. The court did not ask these questions. The court did not ask, Mr. Vaiko, are you being arrested? Has your fundamental right been violated? No. Anybody can approach. That means locus standi does not apply. That is habeas corpus. So the first writ directive that can be issued by the court, by the Supreme Court, for the protection of your fundamental right is the writ of habeas corpus. Clear? Yes. Then what is the difference between PIL and concept of locus standi? In PIL also locus standi does not apply, but we will discuss that in judiciary. PIL is basically an innovation in India. Thanks to Justice Bhagwati, Justice V.R. Krishna Iyer, they have also diluted the concept of locus standi. But we will discuss that in judiciary. But you're absolutely right. If kidnapped, file habeas corpus as it is against private individual. You are kidnapped by the police or by a private individual. Doesn't matter. Someone can file habeas corpus in the Supreme Court. Then something called mandamus. Mandamus literally means we command. What can we command? If a public body is not doing its duty and thereby violating rights, that is what we call mandamus. How? Let me give you one example. The example is you have right to freedom of speech and expression, which is part of your fundamental rights. Or you have right to decent environment, which is also part of your fundamental right. Let's say, for example, here is a public body. Mandamus can be issued only against a public body. Mandamus cannot be issued against a private body, against a private person. It can be issued only against a public body. If this public body has failed to do and discharge its duty. What is the duty? Let's say this public body is Delhi Municipal Corporation. Delhi Municipal Corporation. We don't have a mayor there because there is a tussle between Aam Aadmi Party and the BJP. 3 times in the past, we tried to elect a mayor. Could not happen. Maybe I'll not tell you why maybe, but we don't have a mayor in Delhi. But it is the job of the Delhi Municipal Corporation to keep the Delhi clean, to keep the city clean. I am living in Delhi, and in my vicinity, there is a lot of garbage. There is pile heap of garbage which is not cleared by the Delhi Municipal Corporation. I approached the Supreme Court. My lord, I have a fundamental right. I said, yes. What fundamental right? Sir, right to life and personal liberty. I said, okay, what has happened? Sir, in right to life and personal liberty, you have expanded the scope of Article 21. I said, yes. What is that scope? Sir, you have said right to clean environment is also a fundamental right. Right to decent environment is also a fundamental right. Yes, we have said that, but what has happened? Sir, can you please direct Delhi Municipal Corporation by issuing mandamus? Direct them, tell them that we command you clean that dirt, clean that heap of garbage, because it is not doing its duty. When it is not doing its duty, it is violating my fundamental rights. The court will issue mandamus to the public body. We command that you clean this dirt, you clean this heap of garbage, because by not cleaning, by not doing your duty, you are violating the fundamental right of the citizen. We command, that is mandamus. But mandamus cannot be issued against a private body. Private body in the sense, you file a mandamus in the Supreme Court against Byju's. Byju's is not releasing the test results of the weekly test which was conducted on Saturday. The nation wants to know. I also want to know what is my All India rank, but it is not releasing its results. Can you please direct them? Tell them we command that you release the results. The Supreme Court will say we cannot do that. Why? Because Byju's is not a state under Article 12. It is not a public body. We can only direct a public body. We cannot direct a private body from issuing this writ of mandamus. What mandamus is, when the Supreme Court issues a directive, a writ known as we command, issues this writ to a public body, if this public body has failed to discharge its duty and thereby violates my fundamental rights, that is mandamus. Clear? And in this mandamus, locus standi applies. What is locus standi? Which means by filing this mandamus, you should have been deprived of your fundamental rights. Your fundamental rights should have been violated, not someone else's. If your fundamental rights are violated, you can approach the Supreme Court. But obviously, you cannot file this case on your own. You need a lawyer. But that means it is you who is approaching the Supreme Court through your lawyer. Some other individual cannot. A third person cannot. Mandamus, locus standi applies. Clear? What is DMC? Delhi Municipal Corporation. Just an example. Similarly, there is something called prohibition. Prohibition can be issued against a judicial body or a quasi-judicial body. What is a quasi-judicial body? For example, a tribunal. Just like we discussed in the first class that Indian constitution is quasi-federal. That means neither completely unitary nor completely federal. In the same sense, we have a quasi-judicial body. That means a body which is neither completely administrative, nor completely judicial. It is a mix, such as a tribunal. Tribunal will have members from judiciary. Tribunal will have members from the executive as well. That means it is neither completely judicial body nor completely executive body. It's a mix. That is what we call quasi-judicial body. And that is what we call a tribunal. For example, one such tribunal is Central Administrative Tribunal. What is Central Administrative Tribunal? For example, if you are an IAS officer and then you have a dispute related to your salary, dispute related to your increment, dispute related to your promotion, dispute related to a disciplinary action against you. A disciplinary action was taken. There was a case against you because of which some action was taken. You were demoted. Your salary was stopped. Your increment was stopped. Any dispute. Such a dispute, you cannot directly go to the High Court. You have to go to the CAT, Central Administrative Tribunal. Central Administrative Tribunal will have a mix. Some members will be from judiciary. Some members will be from the executive, and they will decide whether right action was taken against you or not, whether your rights were violated or not, whether fair treatment was given to you or not. And now this CAT is hearing your matter, but it is violating your fundamental rights. You approach the court and you approach the CAT and you say, please hear my side of the story. Do you know what has happened? There is Department of Personnel and Training, which is the cadre controlling authority of IAS officers, which controls the IAS officers. Department of Personnel and Training, which directly is under the Prime Minister. So this Department of Personnel and Training, it has removed me from the service, or it has demoted me, or it has stopped my promotion, or it has stopped my increment. Please give me justice. CAT will hear your story, but CAT is not calling you. CAT is not asking you to present your side of the story. In CAT meetings, we only take into account the government side. We only hear the arguments of the government. We don't hear the arguments of the petitioner. We don't hear your arguments. You will approach the Supreme Court. My lord, I have come running before you. Said, what is the matter? Please have a glass of water. Sit down. What's the matter? Sir, my fundamental right has been violated. By whom? Sir, by a judicial body or a quasi-judicial body. But which one? Sir, tribunal. Which one? Sir, Central Administrative Tribunal. Which fundamental right has been violated? Sir, principles of natural justice. Said, okay, which is part of Article 14, which is part of Article 21. Yes, but what sort of principle justice has been violated? Sir, you said in Maneka Gandhi case that principle of natural justice means nobody shall be sentenced without being heard. Said, yes. Sir, but CAT is not hearing my side of the story. I'm repeatedly asking them, give me time, but they are not listening to my side of the story. But the government side, they listen every time. So my fundamental right is violated. Please help me. Please protect my fundamental rights. The Supreme Court will issue the writ of prohibition. Will basically say we prohibit. Who is prohibited? This judicial body or quasi-judicial body is prohibited from taking this matter further. prohibit, stop this matter altogether because you seem to have violated the fundamental rights of my client. We are transferring this case to ourselves or to other court or to other institution. They will hear this matter, not you, because you have violated the fundamental rights of my client. That's prohibition. Prohibition is similar to certiorari, but with one difference. You approach the Supreme Court and file a petition of prohibition when this matter is ongoing. When this matter is basically pending. So matter is pending before this Central Administrative Tribunal. But while the matter is pending, where the case is going on, your fundamental right has been violated. What will court do? Court will say, we prohibit this body from proceeding further. Drop it. What if this cat has already given the order? It has given the order that yes, the government is right, you are wrong. You have been rightly demoted. It is right that your promotion has been stopped. It's right that you have been removed from the service. It is right that your salary has been stopped. It is right that your increment has been stopped. The government is right. DOPT is right. Department of Personnel and Training is right. You approach the Supreme Court and say, but sir, my fundamental right has been violated. I have been sentenced without being heard. The court will say, we certify that this judgment will not enter into force. That means certiorari, just like prohibition, can also be issued against a judicial body and a quasi-judicial body. But the difference is, prohibition is issued when the matter is pending. Certiorari is issued when the matter is decided. Even if you have decided this matter, but you have violated the fundamental rights of my client, we certify, the Supreme Court certifies by issuing this writ of certiorari that this judgment will no longer enter into force. We will either transfer this matter to another court or we will hear this matter ourselves. But this judgment will no longer be valid. That is certiorari. And in certiorari, as well as prohibition, locus standi applies. And what is this locus standi applies? That means only an aggrieved individual. Who is an aggrieved individual? Only those whose rights have been violated. Only an aggrieved individual can approach the court. Is that clear? Sir, my question are not answered. Where can I approach? Although we are not a state under Article 12, but you don't even need to go to the judiciary. We are here to answer your doubts. Just listen to me. Let me finish this, then I will take up questions as well. Don't worry. My dear, we are not discussing Lok Adalats here. Lok Adalat, alternate dispute resolution, that we will discuss in judiciary, not here. Okay. Then there is something known as quo warranto. What is quo warranto? It simply means what is your authority? In a sense, to qualify for IAS, to become an IAS officer, you need some eligibility. What is the eligibility? First, you should be 21 years of age, maximum 32 if you don't come under any category, any reservation. Then you have to fill the form. You have to apply for civil services exam. Then depending upon whether you clear prelims, mains, personality test in the same go. Then depending upon your rank, your preference, you can be given an IAS, IPS, IRS officer, so on and so forth. Fine. Now, all the students here attending this class are studying very hard, studying 8 hours, 10 hours, 12 hours, and some people 24 hours a day. if it is possible. And then you have a friend who is not studying at all. He's always on Instagram, he's on LinkedIn, he's on other social media platforms, just chatting with people randomly every single time. He goes out, watches Pathan, goes to a coffee shop, comes back. He's not even reading the Hindu newspaper. So basically, he's not preparing seriously for this exam. He did not even apply for this exam, did not even appear for this exam. But when the final list came, his name was in the list. What will you do? You will bang your head. Don't bang your head. Instead, knock the doors of the court. My lord, I have a petition. Said, what petition? Sir, petition of quo warranto. Why? Sir, there is an individual X who has been appointed to a public body, which is a state under Article 12, has been appointed to a public body. But what is his authority? He is not qualified for that. The court will seek response from Department of Personnel and Training, will seek response from UPSC. Come here. So, sir, what? Here is this person X. He has not written this exam. He has not cleared this exam. But he is an IS officer. How? Sir, he is the son of a minister. So what? We issue the writ of quo warranto. What is your authority? Under what authority are you occupying this post? And if this quo warranto is issued, this person is dismissed, removed from his office forthwith. Why? Because Article 16 has been violated. Article 16 says there should be equality of opportunity in public employment. But he is not given equality. He is discriminated, and that too discriminated for his own benefit. And in quo warranto, locus standi does not apply. Which means even if there is somebody who has not written this exam, who is not an IS aspirant, even they can approach the court. Even if there is an individual who has absolutely no link with bureaucracy, even they can approach the court. Quo warranto, anybody can approach the court, which means the principle of locus standi does not apply. But using quo warranto cannot be used to remove a minister. Minister in the sense, there is a minister appointed by the president or the minister appointed by the governor. For example, a minister is appointed to a state government or a minister is appointed to a central government. Can you approach the Supreme Court, file a petition of quo warranto saying this person is not eligible for that post? On what grounds was he appointed? To a public body, to a public post? No, you can't do that. Because appointment is done by the governor or the president. Removal also will be done by the president or the governor. You cannot approach the court when it comes to a minister. But you can come to the court, file the petition of quo warranto if individuals are appointed to public bodies. Maybe somebody is appointed to bureaucracy. Maybe somebody is appointed to electricity board. Maybe somebody is appointed to life insurance corporation. Maybe somebody is appointed to an RBI. Maybe somebody is appointed to staff selection commission. If you're appointed to a public body, but you're not qualified to hold that post, under what authority are you holding that post if you're not qualified? Then you can approach the court and file the petition of quo warranto. Which means tomorrow, you cannot approach the Supreme Court and ask the Supreme Court to issue the writ of quo warranto against Byju's. Said, why? There is this guy, Sarmad. Yes, he is also the vice president at Byju's. Under what authority? Is he qualified to hold that post? Please remove him from the service. The court will say we can't do that. Why? Because it is not a public post. He is not appointed to a public body. So there we cannot decide whether it is suitable, whether he is suitable or not. If appointed to a public post, we can decide the suitability, whether he was eligible or not, whether he is suitable or not, whether he is qualified to hold that post or not. But only to a public body, not to a private body. By issuing all these writs, Article 32 becomes, according to Dr. Ambedkar, fundamental of all fundamental rights. Because this remedy that in case your fundamental rights are violated, you can knock the doors of the court under Article 32 of the Constitution. And by issuing these various writs, the Supreme Court will protect your fundamental rights. Writs such as habeas corpus, mandamus, certiorari, prohibition, quo warranto. And in all these, only for habeas corpus and quo warranto, locus standi does not apply. That means whether you are an aggrieved individual or you are not an aggrieved individual, anybody can approach the court. But when it comes to mandamus, certiorari, and prohibition, only those who are aggrieved individuals can approach the court. Not even their relatives, not even their family and friends. Only they can approach the court. Clear? Relative cannot approach on your behalf in mandamus. No. Now, basically, fundamental rights are till 32. But then Article 33, 34, 35 talks about something else. What does it talk about? For example, there was one Jawan from BSF. He complained about the lack of good quality food given to the BSF Jawans. Basically, he was practicing freedom of speech and expression, but he was dismissed from the service. Number one. Number two, you would have seen that we have National Students Union of India, which is a student body of Congress. We have ABVP, Akhil Bharati Vidyarthi Parishad, which is the student body of the BJP. We have student body of Aam Aadmi Party, Samajwadi Party, Trinamool Congress. But do we have a body of army which is affiliated with the Congress? Is there a union in the army or in the police which is affiliated with the Congress or affiliated with the BJP? No. Does that mean these members of the armed forces, they don't have the right to form unions, associations? They don't have the freedom of speech and expression? There was one member of the Air Force, a Muslim. He started sporting a beard. And when he started sporting a beard, he was dismissed from the service. He went to the court. My lord, my fundamental rights have been violated. Which fundamental right? Freedom of religion. What freedom of religion? I have the freedom of conscience. My conscience says you are a Muslim, you practice Islam. And now I have the fundamental right to practice my religion as well. And I started practicing my religion by sporting a beard. And because I have sported my beard, the government says, the army says, the Air Force says that you have violated the rules, and I was dismissed from the service. Now, the court had to decide whether sporting a beard is essential to Islam or not essential to Islam. The court looked at that Jinnah was not sporting a beard, yet he was a Muslim. Nasruddin Shah, he's not sporting a beard, yet he's a Muslim. APJ Abdul Kalam, he was a Muslim, not sporting a beard. Allama Iqbal, not sporting a beard, yet he's a Muslim. So sporting a beard is not essential part of religion, which means it can be regulated. And that is why if the army has said that you cannot sport religious symbols when you are in Air Force, when you are in army, this is a reasonable restriction. Sir, but what about Sikhs? They are sporting beard, they are sporting turbans as well. Sporting a beard is a fundamental feature of Sikhism, is an essential religious practice of Sikhism. That's what the court has said. But it is not an essential feature of Islam. That means Parliament has been given the power. What Parliament can do, it can modify these fundamental rights under Article 33. So all these fundamental rights from Article 14 to 32, Parliament can modify these rights. But for whom? Not for anybody else, not for citizens, but for those who are working in armed forces. That is why you don't have freedom of speech and expression. That is why you can't form unions, associations, or cooperative societies. That is why even your freedom to practice religion can be restricted by the Parliament. Similarly, if you are members of forces which are charged with maintenance of law and order, that is why police, if you become an IPS, then you can't claim freedom of speech and expression. then you can't form maybe an association. Then you cannot have the freedom to do anything under fundamental rights. So some fundamental rights can be restricted for you. Those who are working in intelligence and counterintelligence operations, for example, if you are part of intelligence bureau, if you are part of raw, which means research and analysis wing. Intelligence bureau is the internal intelligence agency of the government of India. Raw is the external intelligence agency of the government of India. Their fundamental rights can be modified by the parliament. And those who are working in telecommunication systems in the above three institutions. For example, you are working in telecommunication system in army, telecommunication system in police CRPF, telecommunication system in raw and intelligence bureau. For all such people, parliament has the power to modify these fundamental rights. That is Article 33 of the Constitution. Any questions? Okay. Then we have something called martial law. What is this martial law? For example, here is this area, which is part of the territory of India. This is an area. And this area is right now disturbed. There is violence in this area. Maybe caste violence, communal violence, or there is terrorism, insurgency, militancy in this area. Now, police has failed to restore peace in this area. Paramilitary troops have also failed to restore peace in this area. Then what is the alternative that we have? Bring in army. But when you bring in army, you have to give army some protection. Why? Because army is trained differently. Police and paramilitary troops, they are trained differently. Their DNA is different. How? There is protest. And now this protest is turning violent. They're throwing stones at the police. They're destroying public property. The police is trained in a different manner. So first it may fire water cannons, water with force thrown at these protesters so that they may disperse. If that doesn't work, the police may fire rubber bullets so that they may be injured but they will not die. Then they can use lathis to lathi charge these protesters. Even then it is not working. Then they may resort to aerial firing. That means they will fire in the air. When you will hear the sound of the fire, maybe you will disperse. You're still not dispersing. You will now fire, but you will fire at the leg so that it can injure you, but you will not die. When nothing works, they are coming close to you and they may also kill you. They have weapons. Now, in your self-defense, you will fire, you will shoot to kill. So police, paramilitary troops, CRPF, they are trained differently, but army is trained differently. Army is trained just to shoot to kill. That means when this army is brought in this area to restore peace in this area, the army may kill people on mere suspicion as well. The army may think that this is also a protester. This is also a militant. Shoot to kill. Army cannot use knife, cannot use lathi, cannot use rubber bullets, cannot use water cannons. Army will shoot to kill. If this is an area which is disturbed and we need army to restore peace into this area, we need to protect army. And that is what martial law says. When martial law is imposed, all those who are responsible for maintenance of law and order, no action will be taken against them for violating fundamental rights. Martial law is, number one, not defined in the Constitution. Number two, never imposed in India. So what is martial law? We don't know. Why? Because number one, martial law has not been defined in the constitution. Okay. Number two, martial law has never been imposed in India. Then what can we know about martial law? We know one thing, that when martial law is imposed, then during this period when martial law is imposed, all those people who are charged with maintenance of law and order, after martial law is over, no action can be taken against them for violating fundamental rights. Sir, what does that mean? Martial law is imposed today. Now, these are the people who are responsible for maintaining law and order. These people can stop people from practicing religion as well, can stop newspapers from publishing newspapers as well, can kill somebody on mere suspicion as well. That means during martial law period, fundamental rights may be violated. Once martial law is over, then we come into the area of peace. Peace has been restored. When martial law is over, can we take action against these individuals who during martial law violated fundamental rights, abridged fundamental rights, snatched fundamental rights? No. Restriction notwithstanding anything in the foregoing provisions of this part, that means notwithstanding anything mentioned under Article 14, 15, 16, 19, 20, 21, Parliament may by law indemnify. Parliament may pass a law and say all these people, no action should be taken against them when they were responsible for maintaining law and order during martial law. Any person in the service of the union or the state, or any other person in response of any act done by him in connection with the maintenance or restoration of order when martial law is in force. That means when martial law is in force, center and the state may ask some people to maintain law and order, restore law and order, which can be army, which can be police, which can be some other civilians, which can be volunteers. And during martial law, they may violate fundamental rights. But no action can be taken against them because they were responsible for restoring order in India, maintaining order in India. That is Article 34 of the Constitution. So we can say something similar to Armed Forces Special Powers Act. Something similar. Because in AFSPA, for example, in Manipur, for example, in Jammu and Kashmir, if there is an area which is disturbed, army can enter that area, kill people on mere suspicion. Army does not need warrant by the magistrate to carry on search operations. For example, if you have to search my house today, the police has to search my house. The police has to get warrant from the judiciary, from the magistrate, that this is the reason why we want to search his place. But army need not get warrant from the magistrate if it has to search something in a disturbed area. So if this martial law is imposed throughout the country during that period, if there is violation of fundamental rights, but Parliament can pass a law and protect those individuals, saying no action should be taken against them for violating fundamental rights, because they were responsible for maintaining and restoring the order in that territory. That is Article 34. And Article 35 is simple. Article 35 says if fundamental rights are there in the Constitution, who can pass a law to implement these fundamental rights? If Constitution says untouchability is abolished, who has the power to pass a law to punish those who practice untouchability? Who has the power to pass a law, Atrocities Act? Parliament or the state legislature or both? If Constitution says traffic in human beings is prohibited, who has the power to pass a law on immoral traffic? Who has the power to pass a law on bonded labor? Who has the power to pass a law on child labor? Long story short, all these fundamental rights, if law is required to implement these fundamental rights, who has the power to pass this law? That parliament is, that law, that power is given only to the Parliament of India. Parliament alone has the power to enact laws and give shape, give effect to fundamental rights, not the state legislature. That is Article 35. We'll meet tomorrow, 6 o'clock in the morning. We will discuss what is Article 32 and 226, and we will discuss some constitutional bodies such as National Commission for Scheduled Castes, National Commission for Scheduled Tribes, National Commission for Backward Classes, because they are related to Fundamental Rights chapter. And then tomorrow we will start discussion on Directive Principles of State Policy, Part 4. There we will discuss what is Article 31, what is 31A, B, C, what is Uniform Civil Code. All that we will discuss tomorrow. Any questions as of now? Let me know. Sir, is politics service or job? Politics can be service, it can be a profession, depending upon the individual, how and why he wants to take up the role of a politics. So it depends upon an individual. Is it a profession for me? Is it a social service for me? That's about it. NCM is National Commission for Minorities. Is prohibition certiorari issued against private body or public body? Only against a judicial body or a quasi-judicial body. So do we need to read Fundamental Rights chapter from Lakshmikant? Everything that we read, discuss in the class, please read from Lakshmikant as well. What is quo warranto? What is your authority? That's quo warranto. Sir, please explain Article 34. Article 34 says Parliament will have the power to enact a law. What is that law? Through that law, it will indemnify. That means it will protect, it will insulate, it will give immunity to those people who are responsible for maintenance of law and order, peace, when martial law is in place. Even if they have violated fundamental rights, no action should be taken against them. That's martial law. Article 33 is applicable on bureaucrats. It is applicable on these members of the armed forces. Bureaucrats still have all the rights. They have the right to practice religion. They have right against discrimination. They have all the rights. But yes, they have to fulfill some cadre rules. For example, they cannot overtly criticize the government. If they have to write a newspaper article, they have to seek the permission of the head of the department. Those are the service rules which they have to follow. But restrictions, modification on them under Article 33, they're available only for these. If kidnap, file habeas corpus as it is against private individuals. Whether you are kidnapped by state or non-state, whether by police or non-state, doesn't matter, still file habeas corpus before the court. Sir, Constitution is the fundamental law of the land, and Article 14 says equality before law. It means if any provision of the Constitution is violated, then Article 14 automatically gets violated. I'm not able to get how article is getting related to most of the cases. Article 14 basically talks about a law passed by the parliament should not deny equality to others. That law passed by the parliament should not violate equality. That's Article 14. So equality before law. Constitution has already created everybody equally. But then the law passed by the parliament, it should not deny equality. And if it denies, then Article 14 gets violated. Can mandamus be issued to Chief Justice of a High Court? No. There is one technicality, but don't go too deep into that. Just keep in mind, mandamus is issued against a public body. Chief Justice Office is not a public body, it's a judicial body. Which writs are locus standi? Which writs require locus standi? Mandamus, certiorari, prohibition. Sir, police comes under Article 32. Please think twice. It's a good question, but please think twice before you ask a question. State should come under Article 12. Police comes under state under Article 12. There is no such thing as whether police can come under Article 32. If you want to say, can I file a habeas corpus against the police? Yes. Can I file mandamus against the police? Yes. Because it's also a public body. It's also a state under Article 12. Got it? Mithun? Sir, is Article 21 fundamental of all fundamental rights or Article 32? Constitutional experts say Article 21. Dr. Ambedkar said 32. Sir, CJI comes under principle of natural justice in his own case. Nani, if you have attended my previous class, I've told there principles of natural justice, which says a judge cannot be the judge in his own case, a person cannot be the judge in his own case. That does not apply to Chief Justice of India. Thank you so much. See you again tomorrow, 6 o'clock in the morning. We will wrap up fundamental rights in the first half an hour or so. Then we will look at directive principles of state policy. But till 10 o'clock, you can still get in touch with subject matter experts and get your doubts clarified. See you tomorrow, 6 o'clock. Till then, bye-bye. Take care.